Okay, good morning, everyone. Today is October the 1st, 2024. We are here on the matter of Miss Joanna Stolar versus Wisconsin State of Wisconsin versus, State of Wisconsin Department of Corrections, ERD case number 2020-02513. The appearances are the same, with the exception of the complainant appears today, and that is Miss Joanna Stolar. I'd like to first address briefly some housekeeping matters that we discussed yesterday. The first of which was I had asked the parties to delineate as to the claims which pertain to the no probable cause section of this case, which had been timely appealed, but that matter was dismissed from a previous administrative law judge. There seemed to be some discussion and difference of opinion as to whether or not any of those claims survived and would be part of this. The parties did submit their position on, each party presented their position in writing to me. I have reviewed that as well as the case file in terms of what has occurred in terms of the claims in the complaint. There were quite a consistent number of them, and my position and my ruling is as follows. It would appear that claims 3 through 10 appear to apply to the portion of the no probable cause that was dismissed. Claims 11 through 24 appear to apply to the merits portion of this, and claims 25 through 32 appear to apply to the constructive discharge that was part of that no probable cause. So that is my decision on that, based on the information provided by the parties. And I have not had an opportunity to put those emails with the parties' position into the file as I received them. Some things last night, some things very early this morning. Everything was timely. Everything submitted by everyone was timely. So let's make sure that is clear. It was all considered, as well as past decisions and rulings that I've made in this portion of the case. So that is my decision on that. The second item...
Before we get to that, if you'll kindly excuse me here, you made some reference to some things that are completely unclear to me. As far as I understood, you said something like allegations and then listed numbers, and then went on to say other allegations and listed numbers. Are you referring to paragraphs in the complaint or
Yes.
something else?
Yes, the complaint.
Okay. But those aren't allegations. Those are allegations. Those aren't claims. Those are two distinct concepts.
Okay. The claims in the I considered it to be a term of art. Perhaps I misspoke, but until something is either proven at a burden of probable cause or by a preponderance of the evidence, I always consider those things to either be claims or allegations at this stage. Nothing has been decided. No decision in this case has been rendered by me. If we want to refer to it, how about I just say the claims asserted in the complaint that was filed by the complainant are numbered in this complaint. So the numbered, whether we want to call them numbered paragraphs, because it seems to be each paragraph has a number, however you wish to refer to them. But what is available for this hearing are numbered paragraphs in the complaint of 11 through 24. And hopefully that clarifies. All right. Now, I thought I had also asked somebody if people wanted to, in terms of explain a little bit more on this remote witness. I haven't made a decision on that. We talked about her possibly testifying tomorrow. I have very limited information based on what has been submitted thus far. All I have, as I noted early yesterday morning, was just the request from the complainant. I don't know if there's anything else you wish to add.
Well, we had a half-an-hour discussion on this yesterday, so that's in the record. So I'm a little confused on what you're referring to, not having that available to you. Because that's when I responded this morning saying I didn't believe that there was anything else to discuss on this, that's what in fact I was referring to. So if you have
that's what I wanted to make sure.
I'm happy to answer those.
No, I wanted to make sure that was what you were referring to in that email.
Because as I understand it, the witness is some 220 miles away, and again, it's important that she's out of state. She's no longer in, as opposed to several of these witnesses who are in the employ of the state of Wisconsin and are in state. We are asking for an accommodation. I don't think that's any different than their request to have Carrie Beyer appear out of order or anything of the like. This witness, in theory, let's put it like this. I believe that unless she appears voluntarily, which would mean by telephone, I don't think that there's any way for us to compel her absent some order from a circuit court, which I don't see how that's happening. So that, I think, is the main issue with her, is that she's resides out of state, not just temporarily located out of state or out of the country conveniently like Kevin Carr. So that's, I think, why that we should deal with this differently than other issues, and it's just a courtesy to this witness, as we normally do to all witnesses.
Well, there are a variety of ways that one can subpoena an out-of-state witness. You just have to follow the long-arm statute. You can issue a subpoena, have it served in the county, have it recorded in the county in which she resides. That county then takes notice of our subpoena. It just has to be served in the manner of the state that she's living in, following the long-arm statutes. We've done those in other administrative hearings.
She's perfectly willing and able to attend the issue, and she's accepted service. So that the subpoena issue that we frequently are getting into is not really the issue here. The issue is why are we making her drive 220 miles each way for the privilege of showing up here in person?
Well, I think the problem we have is that this is extremely late notice. We didn't even know who she was on Friday. We found that out yesterday morning. That's not enough time for the respondent to have even decided what exhibits they may or may not want to show this witness, to have overnighted them to this witness or however, because you can't cross-examine. You can't examine somebody with a witness saying, do you recognize this document, when they don't even have it in their possession.
Then we have to show it by teams.
Well, you were offered the opportunity to have this entire hearing by Teams or WebEx, and you wanted it in person.
That's right.
And that's why we're here in person. So at this point, my decision is that I will not allow her to testify remotely. Okay, now the next item in terms of housekeeping is the issue of whether or not, hold on a second, Let me pull up my notes.
Excuse me, Judge. We had appearances, and I wanted to make sure that the record reflects that for some reason, although it's your practice to always have a police officer at all of your hearings, there is no police officer present here today, and that strikes me as noteworthy. So I'm going to note that for the record.
Absolutely. I don't schedule them. I can't control whether they actually comply or not. For whatever reason, there is not an officer here. There should be. But once again, they don't work for me. I don't create their schedule. Requests were put in just for maintaining decorum and that sort of thing. And for whatever reason, I don't have one here. So thank you for putting that on the record.
Were those requests made in writing?
No, I did not make. Well, no. I don't know how they were made.
Was Maria Seltzer involved?
I think I made it through the scheduling person that normally puts the scheduling stuff on. As to whether that was forwarded to somebody else because they happen to be on vacation, I don't know. I just simply say this is what's required.
And that's a scheduling person from the ERD or somebody else?
ERD, the same one that sets up the rooms here. I don't do that. I just say I'm having an in-person hearing. These are the dates. This is,
Great, and you conducted that would have been by writing? In writing? That communication?
I don't recall.
Oh, okay.
It was so long ago. I do not recall.
It was so long ago?
Yes, we're talking March, okay?
That's when you asked for a police officer to appear at this hearing was in March?
When I let everybody know when my hearings are and what the dates are, how many days, where it's at, all of that should have been communicated at that time. All right, let's move on.
I'm sorry, I don't think that was, I'm not clear on that. Are you saying that in March you asked for a police officer to be at this hearing or something else?
Attorney Hitchcock Cross, I'll be more than happy to look into all that information for you. But right now, we're going to go through the housekeeping matters, and I will make a note of seeing if I can locate that information.
Well, it seems pretty simple. I mean, either
no,
you
it
did
is not.
this last
It is
week,
not pretty. It is not pretty simple.
Do you not recall at this time?
We're done with that line of questioning. Okay. Once again, the next issue.
Well, I need to be clear then. You're refusing to answer this question at this time on the record as to whether or not you recall back in March if you asked for a police officer.
First off, I'm not your witness, and we're not going to continue in this manner, sir. So I'm going to ask you to once again refrain. And let's move on to the issues.
Doesn't sound like an answer to the question, which I don't understand why that question would be difficult to answer. Can you explain that?
All right. The next thing that I advised everybody yesterday, I think it was after lunch or sometime, that I discovered that there had been an email sent by Assistant Attorney General Jabbar in regards to a subpoena. I am not making any decisions on this whatsoever. I made it aware to the parties. I have not had a chance to respond to him to let him know that I am not making any decision on this. I'm just going to make a few remarks. I think I have made this extremely clear repeatedly that there is no such thing as a motion to quash the subpoena of a person. The Wisconsin Supreme Court has said that is not a thing. I believe it's State v. Gilbert. It's in the decision that I made when he requested a protective order. At that time, that, although 804 will tell you that you can quash a subpoena for, undue reasons or undue deliberate, a variety of situations, the Supreme Court has made it very clear that that does not apply to people. You could, if there was a subpoena ducis tecum, then that would be it. But as a protective order, you can provide certain limitations, some of which are enumerated, but not limited to. I had already issued a protective order in regards to a deposition as well as appearing at hearing. That decision stands. I'm not rescinding it. I'm not doing anything with it. It is what it is. He is free to do what he wants. Attorney Hitchcock Cross is free to do what he wishes in regards to whether or not they appear. But I am not doing anything with that motion. I will send an email to the parties as well as to him at first break to advise him of same, that I'm not superseding that order.
So the problem again with that is, because you recited all that yesterday and you haven't substantially added anything new, that at your invitation we sent to you, at least I sent to you an email reminding you of the case law that I reminded you of last night that you still have not addressed, and which is essentially the same pattern as we've had throughout this morning here, where the critical issue that the complainant raises you do not even address in any fashion. And for this issue, it's simply this. You are making, and that motion in itself is an a priori exclusionary exclusion of evidence. And that is forbidden by Lurk and Burton, Forbarge, I think it is, and Fauertech, Roberge, that's what it is. And who could forget Bowen? And that's an appeals court decision that making it binding on everybody. And it's very clear that the law here is that you are not to make decisions about the evidence until you hear them, that this is an extremely lax environment for the admission of evidence, and that you are commanded by both Lurk and the appeals court to hear all the evidence. And that is why when you don't even address those issues, it's extremely troubling, Judge, because again, it's just more evidence of bias, which is something that has, to quote Nola Hitchcock Cross, plagued this case from the beginning. You have time and time again refused to address, and that is what the issue is. You had heard no testimony, only the assertions of the opposing counsel, and you made a finding of fact in that decision that goes something along these lines. We are unable to depose Petchacek because for some reason you created the illusion and put words into my mouth that I had said that Kevin Carr was the only person who knew about Kevin Carr's decision. And in fact, that was false. It was false when I explained it to you at the time. It was false after, and it was false now. That's what you call a false dichotomy, Judge. It's a simple fallacy that we often learn early in high school. And it goes something like this. Just because one thing is something does not mean that something else cannot also be that. That is that state of being is called mutual exclusivity. This is something else also that the respondent has a hard time understanding as well. And I think we need to lay that out quite clearly. You need to understand, Judge, that when the law, meaning the appeals court and Lurk, tells you that you cannot make a priori decisions and that you put in writing that this person cannot testify at a hearing, and then, and what's really important is you talk for 10 minutes on two separate occasions, not about that issue, but about subpoena and quashing subpoena and how you've lectured the parties on how there's no such thing as quashing a subpoena for a person. And that is essentially what the problem is here again. This is not a fair playing field by any stretch of the imagination, because while there's the appearance of law, There's not actually the addressing of the complainant's arguments. So we might as well be in the situation that you frequently set up, where you just want to hear from the respondent and the complainant need not respond at all, because in fact you're just you're not even addressing what it is that the complainant says. And that, as we've said before, sifting and winnowing is what a judge is supposed to do. Now, when I look at these emails going back and forth between the parties here from just last week, and I think that's also part of the problem, is how that you prejudiced this hearing. You told us yesterday that the only purpose to have the hearing on Thursday of last week was so that you could
I'm going to cut you off, Attorney Cross. No, stop. Stop.
You were never going to hear their motion.
Stop. We are not going to do a repeat of yesterday. All of that's done. The only thing we are going to talk about this morning, and I'm doing a briefly going to be answering my decisions. I did receive your email. I did read your email. In terms of the cases that you cited and burden and everything else, those were very clear in your email. They were read. All of those things were decided in my decision when it came to the order for protection. It is thoroughly discussed in that motion, or that decision, and to say where things had been retrieved and, what had been argued. Perhaps counsel forgets what he argued in his motion for Carr. I don't know. But all of that is addressed as to why it is that I did that. It is not that she's appearing here today and I'm saying, no, I don't want to hear this information, or no, I don't want to hear that information. I can only rely on the motions and the briefs and the things that the parties have put when a motion is before me. That is my decision. I'm not doing anything in regards to Secretary Pachasik, whether she shows up or doesn't show up. I'm not even entertaining that motion. That is all I'm saying. We are done with that topic. We are moving on now.
Well, what I had
no,
got the chance
we are
to get
moving
out,
on
and, well,
now.
I need to get this on the record, Judge, because I think it addresses precisely what this issue was. So again, we had a lot of discussion about this conversation that we had on Thursday. And we had several things that you recorded now saying to us and reasons for having this. And you stated on the record that the point for having that conversation or that motion, and we've got it on record, was that you were going to tell the respondent that you were never going to hear from their motion to dismiss. But in fact, I've got this quote from you. It says, while this ALJ has every intention and hope to inquire from the complainant if she had anything she wished to add as it related to the respondent's untimely motion to dismiss, as the complainant had not consistently filed responsive motions throughout this pleading. And I could go on throughout this letter here where you're setting up a situation either where that you are trying to talk to the complainant without her attorney present, and you say that in writing, and you also identify clearly the reason that you want to have this meeting here, which we all submitted yesterday, was for the sole purpose of dismissing out this complaint.
No, we did not admit that, so please don't. That's your position. I was never going to dismiss this complaint, and I explained to the parties why it wasn't even possible. So, again, we're not going to keep... This is never going to finish. If we keep repeating the same thing over and over again, hoping for a different result, we're getting nowhere. So I'm done with what happened at the Tuesday teleconference. It wasn't a motion hearing. It wasn't invitation wasn't set out for that. It was simply a teleconference.
That's not a true statement, Judge. It
Okay.
says clearly on the invitation, Judge, that it is a motion on the to hear the respondent's motion to dismiss. It clearly said that, and what you just said was something else than that.
I challenge you to look at that. Lurk will find it. It's in the case file. It's titled teleconference. That's what it's titled, and I simply just wanted to give you an opportunity. if you chose to say anything because it was untimely.
The
because
problem
it
with
wasn't
that, Judge, is
but
that
we're
you
done.
sent
We're
certified
done.
letters to both me
I have
and to
to.
the complaint. You do not have
Okay.
to do that
All
unless
right, we're
you're trying
done.
to dismiss the case.
No.
That's the problem for you.
Okay, all right. That's your argument. It's on the record. We're moving on. Okay, we're moving on. The last thing we have to deal with as a housekeeping matter is whether these attorneys are in fact witnesses. Give me one moment to pull up one other thing, please. This comes about as the motion filed by the complainant on August the 8th in regards to a motion to compel the production of documents was what the title of that was. Now, the complainant is arguing that both attorney Olmanson as well as attorney Zacard signed a couple of interrogatories in addition to, as to the answers as well as to whether the noted objections. I did issue a decision as it pertained to that motion. The motion had requested relief. And the relief requested in the introductory paragraph of that motion was an order requiring for the respondent to respond to those interrogatory propounded. Complainant listed 2 different interrogatories. The responses to those interrogatories was claimed to be work product, attorney work product. However, because they signed that, the complainant has argued that the simple signing of those has then made them a fact witness in this case. Several cases have been cited, but and I think we can. It's very clear as to what the definition is of attorney work product, and that you can just look to State Ex Rel Dudek versus Circuit Court. It's an old case. It's a 1967 case. However, the definition is very clear as to what a lawyer's work product consists of, and that's the information they've assembled, any mental impressions, legal theories, strategies pursued or adopted through any type of statement, memorandum, correspondence, whatever that may be, their factual mental impressions, their personal beliefs, that sort of thing. So it's a very broad definition, and it's the mental impressions and strategies that are collected and adopted by a lawyer, essentially after they've been retained or in preparation of litigation that might be relevant to any issues, subject to that. Now, unless there is good cause shown, anything concerning the merits or legal theories of a case is only required upon a complete showing of unavailability of information from any other sources after a showing of a diligent effort, and then only upon a showing of extreme hardship. In this case,
that's for disqualification.
Can I please continue without being interrupted? Thank you. In terms of what we're dealing with here, we have a couple interrogatories that were apparently signed. We have 80401, which will tell us what's applicable and what is not, in terms of what you can even ask for in discovery. And basically, it has to be relevant, and it can't be privileged. That's under the scope. So that would be 80401 sub 2 A, I believe. So you can obtain discovery on any unprivileged matter. Here in this case, the parties respondent did object, cited it was work product, explained why it was work product, and then they went on to sign, but they signed it as upon information and belief in terms of how it was signed. We also know that, hold on, 804, what is it? I think it's in it should be 80408 if I'm not mistaken, that when it comes to interrogatories, that a governmental agency or state officer or anybody acting as an agent shall furnish such information as it is available to the parties. It appears that once that is done, that was what this did. So in response to the interrogatory, it refers to that they've turned over or provided any of the documents in question. In theory, it would seem that they're signing this interrogatory, if anything, just merely binds Department of Corrections in the case to any answers that was provided. It does not necessarily make them a witness in this case. We know also, if you look at a case cited by, I believe it was the complainant in their brief, which is the Franzen case, it's a little dated as well, but that was a case that dealt specifically with healthcare services review and confidentiality of information during a peer review of a physician and their innate inspection and interactions and that sort of thing. But what was important to be gained from that case was it explained the inquiry that had not been done by the trial court in that. And basically what we talked about yesterday briefly is that you have to first, there's two prongs. First, you have to determine whether or not there's the existence of a relationship. I think it's very clear here that respondent has counsel, that we have an attorney-client relationship that exists. It's not enough to stop there. Next thing you have to do is what is the nature of the information sought. Here, in lieu of the motion that this all pertains to, the information that the complainant was seeking in response to their motion was the attorney's beliefs, thoughts, mental impressions as to this case. Their strategies. Why was this relevant? Why was this not? What were you? These are all thoughts. Clearly, that is privileged information. The second interrogatory that was being requested, once again, was to identify every person, respondent, manager, authority, employee, anybody, one of the attorneys, I don't remember if it was Olmanson or Zacard, had spoken to in two unrelated cases that have nothing to do with this case, and look at this Exhibit C. There's been numerous exhibits that have been provided, as well as emails in response to this, and I didn't even bring it up because I didn't even need to get that far in making my determination, is that there seems to be some discrepancy as to whether Exhibit C was ever provided to the party, so I don't know how you can answer something in relation to an Exhibit C if you don't have it, despite however many requests. But again, I didn't get to that. I didn't bring that up because it wasn't necessary. The first thing that 804 will tell you is it has to be relevant, and there is nothing that seems to be relevant about inquiring about other parties and other cases that has to do with the sole issue before this tribunal. So, in following the analysis as to whether or not this is even, is it privileged? Is it not privileged? I did not need to reach that. So, based on the information provided, as well as the actions that appear to be done according to all of the documentation submitted by the parties, and I don't know whether anything there was mentioned yesterday. My notes indicate that passed possibly, in agreeing to their duty to supplement, which everybody's required to, their answers to interrogatories, that maybe there might have been some amended answers or something like that. Again, I have no idea. I didn't look at that because I don't know anything about that. It has not been provided one way or the other. Attorney Cross was very clear yesterday. He's not aware of anything. He didn't seem to have those. I have no reason to doubt one way or the other as to what occurred. But that's not something I need to reach. I do not find that either Attorney Olmanson or Attorney Zacard are fact witnesses in this case. They did disclose in their answers any documentations that they had, which the statute would indicate that they were obligated to do so as agents. But again, the questions that are being asked are mental thoughts and impressions, and they have not, I believe that those are privileged information. So that's my answer as to that.
Well, so
and that is available on
20 minutes. Thank you. We just spent the last 20 minutes going over what you'd already decided yesterday, and you still have not addressed, and even what you in fact decided in 3 hours on Friday after you were reminded that motion had been pending for some months, and had heard and was planning on hearing heard one and was planning on hearing two motions from the respondent. The issue, once again, that you actually have not addressed isn't whether or not 3 discovery questions pertain to privileged material. Again, you've already addressed that. The question that you still have not answered, which again is the pattern that we're seeing here, is that whether or not all of the rest of the questions, just for example, had to do with something at this hearing, and because there's an independent question altogether of whether or not they can be witnesses at this hearing. So I appreciate that you've addressed the issue that you already addressed 2 times now on the 3 discovery questions that were put at issue to you before. I appreciate your responding again and telling us your analysis of that, but you still, again, like with the other issue, have not addressed in any means the issue that we raised, which is, again, by signing under oath the veracity of these questions, and which raises a second point. You found in your decision, based on a question that you asked to these attorneys not under oath, how did they answer these questions? Was it on information or belief or something else? And the statute, in fact, and the sign that they formed, which is what you do have in evidence, as opposed to the question that you asked them not under oath, was it states, according to statute, that they investigated this and that this is true and correct. And that when you put those statements under oath as the truth and veracity of them, then we're able to ask them, and which is the inquiry that you have not made, does that make them a witness at the hearing? As opposed to, does that make those discovery questions compellable, which is the question that you just answered, which again is not relevant to the issue at hand upon which you just then decided about them being fact witnesses. So if you could please address the issue at hand that's actually been raised, as opposed to something else, but then finding on the issue that was raised, as you did with the last 3 issues, I think housekeeping issues, that would get us to where we need to be.
Dear Attorney Cross, please do not misrepresent the language in any document that bears my signature. Thank you.
Okay.
The real question here, Judge, is do you want to have a lawless hearing, or do you want to continue to violate the law? I mean, we've have time and time again have gone over all of the ways in which fundamental fairness has been denied to the complainant here. And again, without even addressing the issue, the fundamental fairness and due process issue that I'm raising here now is that you're simply making decisions based on sifting and winnowing that has nothing to do with the issue at hand. So when you talk about B and C all the time, but then you make a decision on A, that's a fundamental denial of my client's due process rights. That's the 3rd time that I'm raising this today, because it's the 3rd time that you've done it today. And that's why I'm trying to be clear, and I think you're not understanding when you say we've already addressed this, That's the point, Judge, is when you don't give evidence, when you talk about discovery questions, responses, and then you talk about what's applicable at the hearing, it not only displays a fundamental misunderstanding of the law as applied to ERD hearings, but it shows that you're not actually grappling with the issues that have been brought before you. And that, I think, is a further denial of my client's due process rights, which needs to be addressed.
Okay, that is on the record. You know, I think probably part of the problem, and I may be mistaken, is that I keep being asked to address things that have already been addressed in motions. I realize people may not agree with my decisions, and you have every right not to agree. But then you want to know other answers to other things, and they're already included in these things. So overall, in this hearing, to make it perfectly clear, they are not fact witnesses. That is my decision. For the same reasons I have already reiterated, whether you like those reasons or not, that is my decision. You have that on the record. And that is where we stand. I have nothing here that has been provided to me that would indicate in any way, shape, or form to come to any other conclusion. I have explained my legal basis coupled with my rational decision making. And my answers are my answers. What I do not want to do is keep going over the same things over and over again, expecting that there's going to be a different response. That is my answer. That is my decision as it pertains to whether or not either of these attorneys are fact witnesses for the purpose of this hearing. These are the only four housekeeping issues that arose from yesterday. I am prepared to move on. I hope the parties are as well.
Yes, I will
with this
make a
hearing
oral motion
and
to default them for failing to properly authenticate the discovery as here.
your motion is taken under advisement.
And
The respondent has an opportunity to respond. Should you choose to his request for default. What would you like to say?
oh, yes, actually, I had just sent Attorney Cross an email asking him to retract his false assertion and forwarding to him the email that had amended the responses that were signed by Carrie Beyer. And just a sec here. And now I'm going to...
I appreciate that, but what I'm asking for is, do you have a response to his motion for default for having signed interrogatories? That's what I'm asking for now, if you have something.
Oh, well, you know, I don't think that this motion is in proper form and it wasn't filed timely.
It doesn't have to be filed timely. Oral motions, according to statute, can be made at any time during hearing.
Oh, right.
Yesterday
Wonderful.
morning, I asked, he made a plethora of motions. I heard each and every one, gave you all an opportunity to respond. That's the way the statute goes. At hearing, oral motions can be made at any time. So Attorney Hitchcock Cross was well within his rights to have done what he did yesterday morning. So that's clear in the statute. So I'm asking you now, if you would, either of you, it doesn't matter me who, would like to respond to his motion for default because of the answering of the interrogatories by attorneys. So that's what I'm asking for.
Oh, that, yes. Well, first of all, there's no procedure in the statute, and he hasn't cited any case law that justifies a default for attorneys signing two interrogatories. But if he believes that that is justified, then he only needs to look at his client's prior failure to respond to interrogatories that DOC had sent. His client had previously failed to respond, and in fact was compelled to provide responses which were inadequate. And her failure to respond to discovery in a timely fashion that necessitated DOC's request that the tribunal compel discovery responses occurred prior to DOC submitting its two interrogatory responses that were signed by counsel. Moreover, to the extent that this would be any sort of well, actually, I'm just going to leave it as is. There is nothing that no statute, no case law provided by Attorney Cross that would require or even allow dismissal of a case when an attorney simply says, upon information and belief, the persons who had identified them, I'm paraphrasing, the persons who had identified themselves as having consumed intoxicants were thus and such. that was something that a normal person could have actually reasoned out themselves from the disciplinary investigation packet without even needing to submit it as an interrogatory. There were other things that were requested in those interrogatories that similarly could have been easily reasoned out simply by reviewing the interrogatory responses, by reviewing the Teuton's investigation packet itself. So, quite frankly, those were abusive discovery requests in any event. DOC had objected to them and, however, had said, subject to said objection, here's what we've got, at least with regard to some of the So, in any event, there's no case law that says an improperly, having the improper person, arguably, I'm just saying, for the sake of argument, having the improper person who relies on a statute, moreover, sign a discovery response would be justification for dismissing a respondent's answer in this proceeding.
If I could just briefly fill in a few things, and maybe she will need a chance to respond to that.
Certainly, sir.
Thank you. So I think what we have here is they had an opportunity to have somebody else from the Department of Corrections sign these documents. And the statute, I don't have it in front of me, but it's my understanding there's two parts to it. One person signs under objection, and the other person is either that the party themselves or an authorized representative of the party who signs it under oath. And it's that section there. They could have had anybody under the sun do that. Okay. The problem, and this is what's flowing from your decision. So I think that's why I needed the second opportunity to add to this. Is simply this: is that they can't have it both ways. So what she's arguing essentially is that we could have, and I want to be clear that we're talking about all the discovery in this section, in the probable cause section of this case. We're not talking about 3 questions. We're talking about what she responded to at the beginning. Michelle Zacard, it's in the evidence here, signed her name under oath to the first set of discovery. Michelle Amundsen's.
Why are we bringing this up now?
No, please.
I'm sorry.
No.
I'm sorry.
Okay. Don't apologize. It's just, I would like to hear what Attorney Hitchcock Cross has to say. I will always give everybody an opportunity to respond, so please take notes, and then I will give you an opportunity. Just like I don't want Attorney Hitchcock Cross interrupting me or anybody else, I want to give him the same respect because he's entitled to it. Okay? Do you remember where you left off?
Of course, Judge.
Thank you.
So, again, there's section A.
You said there was a first part. That's where I lost you.
Sure. So there, as far as I understand, and I'm talking about the first part, there's the probable cause, and
Correct.
there's the no probable cause. And we're focused on the probable cause issue here.
Yes, sir.
Almost exclusively.
Yes.
Yeah, so though I will say that in the no probable cause issue, the respondent raised essentially this exact same issue as a question of how the service and the signature on the interrogatories were responded to. So they're aware of what the rules are because they've quoted them. So, but I'll leave the no probable cause reference to that, okay? That's why I said almost.
Yeah, because I don't know anything about that.
I know.
So
Okay.
don't confuse me because I have no idea about any interrogatories or what did or did not happen in the first I don't want to know. It's not, that's
All
not
right,
it.
thank you, Judge. The temptation was too much. So I will refocus then.
Okay.
We're back on probable cause. We gave him a first set of interrogatories.
Okay.
And I may be technically labeled third set. Okay, because of the cases or whatever.
Right.
That was signed by, and that's in our exhibits.
Right.
That was signed by Mrs. Zacard.
Okay.
Okay. There are other discovery requests and responses that were signed by Ms. Olmanson.
Correct.
Right. Those are also in our discovery.
Yes.
Yeah. So I want to be clear that when you were talking
Oh,
before,
not discovery. Excuse me. You mean in your exhibits?
in our exhibits. Thank
Okay.
you.
Thank you.
And possibly both in our discovery and in the exhibits.
Well,
too.
I don't have discovery. What I have is just
They're
what's
in the
been,
record.
There you go.
They're in the
Because
record.
I don't want the record to think that I have everybody's discovery answers. I only have those portions that have been.
Okay.
I only have those portions that have been attached to motions.
I understand.
Okay.
That's the only issue that I'm trying to address here is we've been talking about 3, 4 discovery questions that have been said that those are privileged. You've said
Right.
they're privileged. They've argued they're privileged. I understood yesterday that we agreed that that was off the table. Okay, and I want to be clear that nobody is asking to have these people be witnesses in the terms of. I know he's going to say, "What's your secret fee agreement? What's your mental impressions?" I agree that those questions are off. That's what we're talking about, facts. Okay, and that's why I want to make the distinction between sub 1 and sub 2. Sub
Okay.
1 is for the attorneys as to objections, okay?
Okay.
And I agree, attorney signs that part, objections, there's no problem, they're off the hook, okay?
Right.
Now, sub 2, that's why there's a different person that signs that, okay? And the person that signs that, it doesn't matter who it is, it can be an agent, right? They can make the garbage person do it. That's a noble profession, but they can have that person be an agent, right? Doesn't have to be the secretary, is my only point.
Correct.
Okay, so once they make that choice, and as you already said, does that make things privileged? Does it not make things privileged? The question here is then, if we can't ask them questions about the truth or veracity of the statements that they signed under oath, meaning, and we're just talking about them, the respondent. Okay? So if the complainant, which is the situation that we're now in, there's 2 people who signed under oath, under sub 2, as required by law, on behalf of the respondent, that the answers they gave were true.
Okay.
Right. And that's the problem that we're having there is now.
Can I just ask you one question? Did they sign to 45 different interrogatories, or do they simply sign as to 1 or 2?
All of them.
Well,
That's
for-
a false statement.
Well, no.
I'm sorry.
Please write it down.
Sure, and I'll cite to the record if I can, because my record, first of all, is Stolar 1023, and I believe that's in your parlance, that's ERD 1023.
Okay, hold on. Can you give me a second
course.
to pull that up, please? So I'm looking at the same thing you are? Okay, so that's, let me see where we're at. 10, oh my goodness. $10.23. Okay.
Your Honor, if I may say, they were objected to, I mean, if you look at, it is objection, 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 objection. Let's see here.
All right.
Can we,
And so it
Well,
isn't as
hold
though
on.
she signed a boatload of interrogatories.
Okay. First off, I simply just want to be on the same page as Attorney Cross, so I can follow his argument. Okay,
Great.
I realize I'm old, but I really want to listen to what he has to say and want to follow along. Okay, so you're starting on.
I just have one page, which is it's the end of a page of 404 documents.
Okay.
And it says ERD 1023. Do you see that there at the top? It says as to objections.
Yes, I do.
Okay, and I'm looking further down where it says as to answers.
That is correct. I
Okay.
see that as well.
And then this is in Michelle Zacard's name.
Correct.
And it's saying that she's the legal counsel and authorized agent. So we got that part right. Okay? We're all clear that she's the authorized agent. Then it says, I have reviewed the above answers to interrogatories which were prepared in reliance on information from officers, agents, employees, and records of the State of Wisconsin Department of Corrections. Okay?
Okay.
So we've got 2 things there. There's officers and agents and employees, okay. And then there's also records that she's relying on. Okay?
Correct.
And it says the answers are true. That's except to those which are answered on information and belief. And remember, last night you asked them, and this morning you ruled that they were just answering under information and belief. But in fact, that's not accurate. And what it says is the answers are true, except to those matters answered on information and belief. Right? So, to my understanding of the English language is this. When all the matters are true, except for the ones that are on information and belief. Excuse me, madam.
Please refrain from being unreasonably loud. Thank you.
Okay. So, I hope everybody's ears have recovered after that. So, that is that one there, and it says it's signed by Michelle Zacard.
Okay.
And then it's notarized.
Okay.
Per sub 2 on the statute.
Got it.
Okay, so we have another one?
No, can we do it one at a time?
Okay.
Just simply
So if
because...
you have questions, I'm happy to answer them.
Yeah, I do. Okay, so I'm looking at that entire set of interrogatories.
Okay.
It's tight, and that's on ERD 1020 is where it starts. Okay, so we're dealing with interrogatory 6, 7, 8, 9, and 10.
Sure.
Okay, answer to interrogatory 6 and 7 were the ones in your motion. They objected to those answers as work product, privileged. So that was the answers to those. Answer to 8 was that it's not within the scope of discovery. There was an objection to that because you're asking for attorney thoughts and recollections, and that she has already provided those investigative materials. So that again is a noted objection.
Sure, Judge.
Answer. Hold on.
Okay.
Let me finish, and then
Because
then
I
you
think
can-
I got the tone of what you're saying, so I'm anticipating it, and I'm just asking maybe if we go to 1022.
No, because I want to make sure we go through each
Great.
one of these things because I might be reading them wrong.
Right. Well, I've got one maybe that.
Okay. And then I go to 9. It's the same thing. We've got an objection. It's unduly. It's not going to result in anything. And you wanted to know all the people in the interviews. Apparently, you had already received a packet of stuff, and you had already been provided. So they gave you the answer. They're the ones that provided you with the packet of stuff. So now we get to a number 10 as to, again, you're asking for beliefs as to why you think this, why you think that, and that again is part of the attorney strategy as to how they're going about this, why they look at this. Nonetheless, they did tell you that they did, this is, I've seen this answer numerous times in the motions that have been filed, that, basically because of the police reports that you guys already have, that there seems to be something in discrepancy with police reports or some statement that was given by this Stephen Jabinski. I have no idea who these people are, but anyway.
Great.
So you have
but
that.
Thank you for focusing on that, Judge, because that's, I think, what we're talking about here. Okay, so that is the exception here that deals with and what is, I think, unassailable and cannot be gotten around. It says, and I'll read it out loud here: without waiving the objections, the complainant has been provided with discovery materials that indicate discrepancies in the report of Stephen Gerbinski made to law enforcement and to respondent. And now that may be something that they've put in other times. The point here is that it was made under oath by that person there. That is Michelle Zacard. And so it's that fact that we're not able to test. And whether it's an opinion, however you feel like that, that is the position of the respondent that they made under oath and that they put down on paper and signed again as to the facts. The answers are true except to those matters answered on information and belief. And it doesn't say on information and belief here. It says the complainant has been provided with discovery materials that indicate discrepancies in the report of Stephen Gerbinski. And we're entitled to take that either as true, filed under oath, or if it's not filed under oath because she's not a fact witness, then we're entitled to default. I think that is the thrust of the matter right there.
Okay, I'm not sure where we're getting the default part. We'll get to that.
Okay.
But we have the answer, complete answer is it's objecting as it's not clear as to the source of the belief. Because you're asking, why does respondent believe, who within
right,
that?
That's sub
okay,
A,
all right,
and then there's sub B.
And then it says, because it's unclear, so if the source is as to the response to the initial complaint, then they're objecting as to the grounds indicated in answer 8. So let's go back up to answer 8. And what is that response? Because it's the same thing. It refers you to go
Right,
back.
the respondent has already provided the complainant with the investigatory materials in this matter that provide the names of witnesses who would have seen the complainant writing on the UTV. That's another fact.
No, read the first
I
sentence.
did read the first thing too. That is also, I get where you're going.
It's
but
saying,
you also you can't just look at some information that you want to. You got to
oh
look
no,
at
I
all.
want to. I've been trying to read the whole paragraph.
Great.
You keep wanting to refer me to just a particular sentence. So the actual objection starts with objection. A written response to the complainant by respondent's attorney is not within the scope of discovery under 80401. Complainant is asking the respondent's attorney to recall who she was referring to in response. Respondent attorney's thoughts are not discoverable under the work product doctrine. Then it goes on to the last sentence, is the respondent has already provided complainant with all the investigative materials in this matter that provide the names and witnesses of that. So once again, where she's responding to attorney privileged, attorney work product, which is her thoughts, her mental impressions, her strategy.
And her previous submission, Judge. That's the part, again, you can't ignore. This last sentence there, the respondent has already provided the complainant. That's a fact statement that we're entitled to rely on as to being true or not. Otherwise, that's what interrogatories are for, Judge.
Okay, well, I've got another question for you. When you're dealing with somebody who is a government agent, which I think we all have agreed that based on who they are, who they represent, that the statute requires them to, if they have information, to provide it. But it sounds like they've complied with whatever the requirements were under 804. So I'm still not understanding how we are getting anything.
Great.
Because it says under 80408, unless we're dealing with a prison, that's 804015, because it directly refers to that a state officer, a governmental agency, state officer acting as the agent shall furnish such information as is available. That's it. So I'm not...
No, Judge, the statute that we're talking about is the statute that says the answers must be signed, the objections can be put in writing, and And we're also talking about 80602. But we're first, before we get to that, we're talking about the response to discovery. And again, as we've gone through, but you haven't noticed in what you're talking about now, is that there's a sub 1 and a sub 2. And I thought we were on the same page that sub 1 was for the objection and sub 2 is to the facts under oath. And that's the problem that we're not getting over. That's the hump that I don't think, I mean, I see your questions, but I don't see that part being resolved, that somebody has to have signed this document under oath. And if they're not fact witnesses, and we can't ask them what happened, then the problem is that it's no longer, we have no ability to rely on these facts that they've put in here because we can't question the witnesses who created them. And that, Judge, is the problem, is sub 2. They had an option to have any one of their agents sign it, but they chose to have it. We agree. We're all on the same page, Judge, I hope, that they can sign them. It's just the consequences that flow from them signing them. That's what the issue is.
And I think, if I'm not mistaken, I've already said the only detriment that I'm able to find on point is that as an agent for a government agency who signs an interrogatory, all that is done unless somebody, and nobody's been able to provide it because there is no case law on point as to someone signing an interrogatory that is an agent, would be that it would bind this respondent to the answers that have been provided. And that was part of my ruling.
Case law, if you sign something under oath, Judge, that means something. That's why it says
does.
Signed under oath.
It does.
Right.
It means that whatever answers they've given, they're bound to. They're bound to. But again, I am not finding that they are fact witnesses on any of these interrogatories. I very well could be wrong, and I hope that if for some reason this case gets appealed, because I haven't heard any evidence other than testimony yesterday, that Lurk will then slap my hand and correct me, and we will all have something definitively moving forward.
Right, but you know this case is getting appealed because of Gellhardt one way or the other. I mean, you know that. The department knows that. Everybody knows that.
Okay. I think I'm hoping this will be the last time I have to say this. Whatever happened over there, and by over there, I mean the probable cause stuff, okay? I know an appeal's been filed, but Lurk's not going to hear that until this portion is done, okay? So I don't know what he did if this issue came up again with this, okay? All right? But what I'm talking about are the decisions that I have made, the rulings that I have made in the event that my portion of the case gets appealed. I'm hoping that Lurk will make a decision so that it's very clear going forward to anyone who handles any of these cases what it should be.
That would be hope for all of us. We'll see what happens. I'm ready to call Mr. Grabinski if you are.
Yes, those are all, well, I did let you say something. So now, is there anything in response, either of you? Now look, we're going to go very briefly. It was literally just, as he requested the motion, for default for signing the interrogatories.
I would object to it. I don't think it's appropriate. There's nothing to back it up. And the statements that are signed in the interrogatories by me are all objections. They don't say anything. There are no facts whatsoever in those. I've been waiting for this case to move forward for 4 years. And I've been waiting to hear from complainant's witnesses. I'm still waiting. I still don't know what's going to happen in this case today. But I believe that trying to call the attorneys, the respondent's paralegal, the numerous individuals who are higher ups are for the purposes of harassment. They're not to get to the truth in this matter. And I don't think that we've been provided any case law that indicates that under these circumstances and these facts in this matter, with these interrogatories that don't have any answers. There's no answers whatsoever in the interrogatories I signed. There's nothing. There are no facts. And I'd appreciate you not laugh because I was quiet for you.
Okay.
The
The record's going to reflect that the parties are going to refrain from any sighs, gasps, giggles, any type of conduct by anyone in this room. Please. Okay? I don't know how else to express. I insist on professional conduct and decorum from everyone, including myself. So hopefully that will be the last time that needs to be said. That being said, I am ready to move on. Attorney Hitchcock Cross, sir, this is your case. Who did you say you wanted?
Mr. Grabinski, but I was a little premature there. I want to direct you to Stolar 1057 here, which is electronically signed by Michelle Zacard, but not notarized. So we're going to raise that issue that these
I don't
aren't
hold
signed,
on.
they're not notarized.
Whoa. Okay. My apologies. Attorney Hitchcock?
1057.
I don't know what we're talking about. What is this? Is this an
Sure, this is
exhibit?
another, yes, an exhibit, 1057.
Whose is it?
This is ours, so it's ERD 1057.
Okay,
This
hold
is
on.
another example.
All right, hold on. Because I'm done.
Sorry, I'm really sore.
No, I would like the record to reflect, Attorney Zacard is injured. She disclosed yesterday and has authorized me I can disclose it on the record. She has a broken back. So the details of which are not pertinent to this record. However, from time to time, she is going to need to stand up and move. I've asked her to move in the direction either behind her co-counsel or over in the direction of me, not to go near the witness or anything like that. Hopefully it will not be disruptive to anyone, but she's got a broken back. She needs to be able to move. And I've given permission for that. I don't want to speak for Attorney Hitchcock Cross, but I believe yesterday he had no objections to that. Does that?
Yeah, of course not.
Okay. So that's what that's about. Okay. So I thought we. So what are we doing
I'm
now?
sorry.
Page what now?
We're on 1057.
Okay, let me get there, please.
Yeah. We can go through all these 112 responses if we want.
I would prefer not to. I think
Okay.
if your motion is the same that you just made a motion, I will give you a continuing motion just for the record. We don't need to go into all of them.
Great. I just wanted to point out that
If you could just give me the ERD numbers.
ERD 1057 is my understanding based on what you said yesterday.
Okay, that is this. I'm going to give page numbers throughout, so that's where it ends. Let's go to the beginning of that, and then correct me if I'm wrong, sir. This would be. Hold on.
1024, I believe.
Oh my goodness, really? That many pages?
We asked some questions.
Okay, all right.
Can we just cut to the chase, please, and have everybody look at section 137.15 of the Wisconsin statutes?
Well, hold on. I want to write down his numbers first. Okay, so we're going to have a standing objection because we can't do this for 6 days. Oh, standing objection, and it started at what page? Sorry again, 10 what?
1024
Okay, ERD
and 1057.
1024 through 1057, and you're asking me to go to which statute?
Let's see, first of all, we have the electronic signature law, let's see, 137.15. Sub 4, if a law requires a signature, an electronic signature satisfies that requirement in the law. And then also sub 1, a record or signature may not be denied legal effect or enforceability solely because it is in electronic form.
Well, if that was the case, we wouldn't be able to have done anything in this case because I have so many things that have been filed by both parties with electronic signatures.
Yeah, I know. There's no issue with electronic signature that I have, so I hope that's not it.
I didn't think that was the issue.
No.
I thought the issue was going to be more of what we've already said, that people were signing things.
Two issues, and if I can just have the chance to explain it, then we can go on. So we've got
Okay.
here through 1024 through 1057, we've got replete with responses, in fact responses by Ms. Sicard here. And I just want to point you to 1057 where it says respectfully submitted this 19th day as to answers. Now she doesn't sign this one under oath and she doesn't have it notarized. She just electronically signs it. So we're not objecting to the electronic signature. We're saying again, because this was not signed under oath as to answers as required by the statute, then that is a deficient discovery response, and therefore...
Okay, which page are you looking at now?
It's complainants exhibits,
Okay,
1024 to 10...
Okay, there, Attorney Cross is mixing apples with oranges here. The responses to the requests for admission, just a sec, are the ones that had electronic signatures.
So I don't know of the law that they cited a law that stands for a proposition that you can electronically notarize yourself.
But
not
it's
Well, well, wait a
not
minute.
notary. I mean,
But hold on.
these are requests for
These are
admission.
requests for admissions.
And this is, you know, again, this is.
Hold on.
Can I please have a standing objection to any misrepresentation of law or fact or status of documents for the rest of this hearing?
Okay, hold on. Standing objection. Respondent. Misrepresentation of law and fact. Yes, you could have a standing objection to that. Now, I'm still dealing with standing objection from attorney
I think we've
Hitchcock Cross. I've got 10 ERD.
1024 to 1057.
Okay.
Those are two separate
Wait a
sets of
hold
documents.
on. I cannot have. First off, excuse me. Hold on. I cannot have people talking over one another. Somebody eventually is going to have to read this thing. So, in looking at what these things are, which is what I wanted to do to begin with, okay? These are requests for the production of documents. That is 1025 through, let me see, that's 1025 through, come on. What was happening here? All right, there goes the little mouse. 1032. So 1025, because I'm not counting the cover sheet. I appreciate them being put in because it's just so helpful. So 1025 through 1032 are production of documents. Those do not require a sworn signature. Okay. Then the next set of things are requests for admission, and those begin on
1033, I believe.
admission, and those begin on 1033. And let's see where those end up.
1057, I believe.
Boy, those are a lot of them. Okay, I think I'm going to go to 1058 because part of it cuts off and goes to the next page, and I want for inclusion.
That makes sense.
Okay, so I'm going to go to 1035 to 1058. Those are all requests for admission, and again, those are electronically signed. People can sign to that. So I don't know if you necessarily want that to be a standing objection. Do you still?
No, I'll retract that.
Okay, that standing objection has been retracted by Attorney Hitchcock Cross. Okay, all right, now can we call your first witness?
Yes, please. Do you want me to get them? Oh.
However, I don't mind. And then just so I have it, it's Stephen Grabinski?
That's what I'm trying.
Okay. Okay, and we're going to start around 11. 10. All right, sir, if you could just take a seat in that red chair down there, please.
This would be the one.
Yes, sir. Okay, good morning.
How you doing?
I'm told that you are Mr. Stephen Gerbinski.
That's right.
Did I pronounce your name correctly?
You did.
Okay. I'm an administrative law judge, Larissa Benitez Morgan. Welcome. Thank you for coming today. I'm going to preface this. If anyone, including myself, asks you any question that is confusing, you don't understand, you're not sure of, please ask us, and I will have everybody rephrase or make it make sense. If at any point you are not sure or you do not know for a fact what the answer is, it's perfectly acceptable to say, I don't understand, I don't recall. Those are all good. What we don't want you to do is guess or speculate, okay?
Fine.
Um,
I'm 76. I'm a little hard of hearing, so sometimes it's,
Well, then
it's a
tell-
factor, but otherwise.
well, if you can't hear,
I
can
don't
you...
take any drugs and medication or nothing, so I'm all aware.
Okay, but if you can't hear, including myself, please let us know, because otherwise we're going to think you heard the question. And there's nothing wrong with saying, could you repeat it? Okay? I don't want people yelling at you, but I want to make sure you could hear, okay?
I was in the Army. I'm used to getting yelled at.
Well, I prefer not to yell. It requires way too much energy. All right, so if we're ready, if I could get you to raise your right hand, please, sir. Do you solemnly swear or affirm that the testimony you're about to give today, it will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may lower your hand. Attorney, do we need to wait for him?
No,
Okay. Attorney Hitchcock Cross, your witness, sir.
thank you. Good morning. Can you tell everybody your name?
Stephen M. Grabinsky.
Stravinsky. Okay. And do you know Joanna Stolar?
I do.
How do you know her?
I've been teaching her how to hunt and fish for years. I've known her since she was a little kid.
Okay. That was going to be my next question.
Could I interrupt? I forgot, sir, and this is my fault. Could you spell your last name for the record?
Gerbensky.
Thank you. My apologies for interrupting you, Attorney Cross.
Okay. Have you ever worked for the Department of Corrections?
No.
Okay. Are you aware if Joanna Stolar ever worked for the Department of Corrections?
Yes.
How do you know that?
Well, she used to, I'd say I've known her for a long time. I remember when she got the job.
Okay. And when she got the job, at any time did she talk to you about how the conditions at the prison?
Yes.
Okay. And did she ever tell you about what it was like to work with the other workers there?
Yes.
Okay. And at any time did she complain to you about any of the workers at the prison?
Yeah, after she had her boob job, she said that Jason and his buddy used to harass her all the time. They wanted her to show them her tits. I'm like, I couldn't believe they did that in the workplace.
Okay.
But then when we were at the bar, they did it right in front of me, and they thought I was her dad.
Okay,
They still
give
did.
me a second. I'm with you here, and I hate to interrupt you, but give me. I'm going to ask a bunch of slow questions that'll get us there in a fairly slow manner. So I hope you can bear with me, but it's just my style. But I can take it then that you know about the fishing trip. Is that fair?
Right.
Okay. Where was that at? Do you remember?
It was on Lake Emily.
Lake Emily.
By
Okay.
the Schaumburg Supper Club is where we parked. That's where we went afterwards.
Okay. Have you ever been there before?
No.
Okay.
Emily, I have on the lake. I fished the lake, but I've never been at the Schaumburg.
Nah, that's what. Okay, that's my question. So you know how to fish?
I've
Ice
been
fish.
fishing since I was 6, yeah.
Okay. Well, there was a couple of things that had to be explained to me, so hopefully you can explain them a little further there.
That's what I'm here for.
All right. And I'm going to break this up, hopefully, in a couple of portions of time here. Okay, so right now I just want to focus on before the fishing trip. Okay?
All right.
And I know it's a couple of years and it's hard, but we're going to try to focus on that. We'll do the best we can. Okay. Before the fishing trip, did Miss Stolar complain to you about working with any of her coworkers?
Like I said, she complained about the harassment.
Okay.
They were,
Okay. And did you ever hear about Alicia Miller at all?
Objection relevance?
We already, the things pertaining to the no probable cause. So I'm going to ask you to go
Even looking at the
very
complaint-
lightly on that. Don't go into great detail as to any of the portions that we discussed prior. that pertain to allegations prior to 10 and the complaint. Do you need a copy of the complaint?
have the
I can
complaint,
print one
thank
for
you.
you.
That, just to cut to the chase, you're telling us we can't talk about Alicia Miller. That's what we're hearing?
Yeah.
Because, and you've read Rutherford, and you know that, I mean, this is completely
Well,
illegal, and you're still doing it? Is that what's
That
going
portion
on?
of the complaint was dismissed. We already have discussed that ad nauseum as to those issues that relate to her. We're talking about issues 11 through 24, those paragraphs in the complaint, because the others are dismissed for the purposes of this merits hearing going forward. So if we could focus on issues 11 through 24, that would be fantastic, sir. Thank you.
Are you aware of whether or not the complainant filed a complaint against Alicia Miller?
Objection relevant?
I don't recall
Well,
exactly.
hold on.
Well, what,
Oh,
you know,
so- again, my fault. Didn't give you the rules. If somebody asks you a question and then you hear somebody else say objection, stop talking. Don't
Okay.
answer. I will find out what the objection is. I will give the person who asked the question an answer to respond, and then I'll make a decision and let you know whether or not you can continue answering that. So your objection was,
The whole Alicia Miller thing is irrelevant. I mean, those allegations were dismissed.
the allegations were dismissed. However, simply the one question, was he or was he not aware, I'm going to allow him to answer that question, but we're not going to be, I will not allow us to probe into what those allegations were. So you can either, that's either a yes, I know, or I don't know, as to whether you know there was a thing. That's going to be my ruling on that, having given earlier rulings prior to you coming in.
I do remember talking about it, yeah.
Okay, and you know the girl lieutenant, do you know who that is?
Yeah,
Okay, and is that the person she's making the complaints about?
yeah.
Okay. And did she ever talk to you about the Department of Corrections investigating any of those complaints?
Maybe she did, I don't recall that.
Okay. And was there issues about the lieutenant being, for example, wanting to be the hottest person in the prison? Do you recall her saying that?
Yes,
Okay. And I think you testified earlier at some point, and you used the word boob job, right? Do you know approximately when that happened, before or after the fishing trip?
it was before.
Okay. And how do you know that?
Well, you said I know her, she's a close friend.
Okay. I mean, in other words, she told you.
Right.
Okay. So how did you come to, did you go to the Lake Emily fishing trip?
I did, I got there late. She was already, everybody else was already out on the lake.
Okay. And how did you come to get invited to the trip?
She told me about it. She wanted me to come along. Like I said, we fished together a lot. And
Okay. And were you aware before you got there that this was a DOC event?
right.
Okay, how did you learn that?
She told me.
Okay. And when you got there, what kind of people were there?
All the people she worked with, I guess they're all from Department of Corrections.
Okay, and how do you know they were all from the Department of Corrections?
Well, I don't know for a fact. I mean, that's what the thing was. It was, either people or people they knew that would.
Okay. And was there a sign-up sheet, or how did you?
No, I just walked out on the ice.
You just walked out on the ice. And did you ride anything to get there, or how did you get out? You just walked up? Okay. And about how far away from the Schaumburg bar was the fishing spot?
Half a mile. People were spread out, in a big area there, but it was probably half a mile from shore.
Okay. And I assume there's a bunch of holes in the ice, right?
Right.
Okay. Are there any shacks or anything?
Yeah, they had some. There wasn't any shacks, but they had some tents set up.
Tents. Okay. And I guess, which is leading to my question of, were you able to see basically everybody that was on the ice at one time?
Pretty much. Like I said, there was one. It seemed like there was a tent further over that I never went over there, so I don't know who was in that one. But I talked to a lot of the people that were right in the immediate area.
Okay. And when you walked out there, did you walk out there with Miss Stolar?
No, she was already out there. She went with some other guy. Because normally she uses my fishing equipment, but she went out with somebody else and just I can't remember the kid's name, but she was using his tip-ups.
Okay. And tip-ups, that's something that helps you fish, is that right? Okay. Judge, I'm getting a sense I don't need to educate you on ice fishing here.
You don't need to educate me on fishing.
Okay.
I tie my own flies. I fish. It's one of my pastimes for things. So
All right, well, then
I'm
I
well
will-
aware of a tip-up.
I will leave that unexplained then. I'm more happy
You're welcome to
than-
put it on the record for anybody else who wants to read it. But,
All right, well then,
But I've never been to this lake, so I can't tell you anything about it. So
I appreciate
I'm
that.
welcome to hear.
So, okay, and about how many people do you think were there fishing at that time?
Boy, I don't know. Maybe 30.
Okay.
There was a bunch.
And I think part of what I'm trying to understand is, there's 30 people there. Are they all? Can they see each other? Or are they all close? How
They were
far
all
away?
spread out. Most of them were in little groups.
Okay.
You know what I'm saying? Groups of friends or whatever.
Was there some sound over there that I should be?
I was about to make an objection, but he began answering before I could do that.
Okay. So, okay. So, at what point did you meet Miss Stolar?
Well, as soon as I got out on ice, I walked around and found her.
Okay.
Because I wanted to know where she was at, and I put in my own tickets after that.
I'm sorry, I didn't hear that. You
I put in, after I found her, then we went out, I drilled some holes and put my
put your own stuff out.
own tickets in.
Okay. And is this in the morning? What time of day is this?
Late in the morning.
Okay. So after you put up your tip-ups, what happened?
Wandered around talking to people.
Okay, and these are DOC people? Did you know any of them before?
No, never met any of them.
Okay. And were they wearing, what kind of clothing were they wearing?
Most of it was ice fishing stuff because it wasn't really cold. It was really warm actually.
Okay,
But everybody, you dress for the cold. And
okay. But it wasn't, people weren't in their Department of Corrections outfits or anything?
no.
Okay. And were people drinking then?
Just about everybody I saw was.
Okay.
I don't drink when I'm fishing. I never have. Fishing around year's time afterwards for that.
Is that one of the reasons that you were asked to come to the
Objection.
fishing tournament?
I just
Whoa. She said
I'm
objection.
going to withdraw that objection.
Okay. You may answer the question. What he asked you, you had said everyone you saw was drinking, and he asked you, was that one of the reasons you came? So I'm not sure if you want to clarify that as, I don't know, designated driver or something. 'Cause
Sure,
I think
I
that's
mean-
where you were going.
Right, but the first question, I guess, is, were you there to be a designated driver?
Not really. I drove myself up, but I don't. I say I just don't. I was taught not to drink while you're fishing. I don't enjoy it until I'm done.
I understand. Okay, but that's so. Then the second part of my question is, you were sober the whole time.
Exactly. Till
Okay.
I had Manhattan or 2 Manhattans at the bar when we got done.
Okay. And just did you see anybody else who was sober there?
Well, I don't know if they were drunk or sober, but just about everybody had a glass or a
Okay.
can or something in their hand.
Got it.
So I assumed they were drinking.
Okay.
I was offered, because I didn't have anything in my hand, they were offered half dozen times to have a beer or whatever with them, and like I said, I just don't do that.
And did you see anybody who was visibly intoxicated at that time?
There's a couple of them that were on the rowdy side, yeah.
Okay. And I don't know much about the licensing of fishing, but is there a license that's required to ice fish at that time?
Yeah, I used state of Wisconsin fisher license,
Okay, and you had one?
yes.
Okay. And do you know if other people had their license?
Objection
Never asked
relevant?
Okay.
I'm going to allow it for what he knows of. Again, I'm not sure of the relevance either, but I'm going to allow the question. Are you aware of anyone else that you saw fishing as to whether or not they had a license?
Don't know,
Did anybody ask you if you had a license?
no,
Okay. And was there anything preventing anybody from fishing without a license that you saw?
no.
Okay. What's the next thing that you observed when you were there?
Everybody seemed, most of these tournaments are about having a good time, and everybody was having a good time.
Okay. And I mean, I don't know what that means standing on the ice, but I assume that's standing around drinking and talking, or is it something else?
Oh, yeah, like I said, at the end of it, it was everybody kind of got in a big circle, and we were all talking, and that's when Jason grabbed her from behind.
Okay, and let's just pause on that for 1 second. Everybody, we're still talking about 30 people, more or less.
Yeah, there was, just about everybody, I think, was all in that circle.
Were you in the circle at that time?
I was.
And was Joanna in the circle?
Yes,
Okay. And was there anybody else that you knew of who was in that circle at that time?
I said, I don't know any of them people.
Fair enough. Okay. But so on your right and your left is two people. They're drinking, and you're talking to them.
Right.
Okay. And that's something I may have some experience with, unlike fishing, is being a sober person at a party. And I mean, you sometimes feel, at least in my experience, that everybody else is on one page and you're on another. Did you have a feeling like that?
No, I get along good pretty much with everybody.
Okay.
I like to, meet people and converse. So there was I don't remember his name. There was the one older guy that I was talking to at the time. He was a pretty nice guy, and I said I don't remember his name, but he.
Okay. And how many other older people do you think were there?
Objection, form of question?
Yeah, I don't know what you mean by older.
Well, whatever he means by older.
Well, I'm 76, so everybody was younger than I am.
I get that. I'll back that up for everybody's help there. Just a second ago, I understood you to say that you were talking to somebody next to you who was an older guy.
Well, he was probably in his 50s.
Okay.
Okay.
So with that definition of older in mind, which
Okay.
I assume
Yeah,
is
it was.
going to
It
freak
was
out
all
somebody.
different ages.
Okay. Now I got it. But
Okay.
do you feel like, was there a substantial cohort or a group of people that were older, for lack of a better word?
A lot of them were, yeah.
Okay. I got it. And, okay. So now we're in the circle, on the ice. Is there like any fishing gear in the circle, or is it just
No,
empty?
Objection leading.
Standing around talking.
We've had
Okay,
a lot
okay.
of leading
Oh.
questions I haven't objected to, but this is getting too far.
All right, I can take that.
Okay,
in
well,
mind.
hold on. Make sure if you're going to say objection, say it loud enough. And that way, Mr. Gabinski can stop before he answers. And I'm going to allow the question, but Attorney Cross, if we could kind of avoid the leading questions, that would be great.
We could kind of do that. Okay.
Thank
I
you.
mean, with the old, what was I supposed to do?
Oh, I mean, well, I again,
All right.
clarify that, but
Fair
okay.
enough.
All right.
So, okay. You're in a circle. Again, there's Ms. Stolar's in a circle. There's at least 28 other people there. Everybody else is drinking, and Miss Stola's included in that. She's drinking too, right?
Right.
Okay. And is there any incident that happened at that?
Well, that's like I said, when he, that's when he grabbed her.
And and pause for a second. When you say he, do you know who you're talking about? Do you know that person's
Jason.
name? Jason. Okay. And do you think his last name is Teuton?
It was, yeah.
Okay. And so Jason, and please describe for us what happened.
Well, he started out like he was gonna give her a back rub, then all of a sudden he slid his hands down, put them on her boobs, and he was like, he lifted her right off the ground. I'm surprised he didn't break one of the inserts he's got.
Can you?
And he's grabbing her like this, and then his buddy came around.
Hold
on.
Can we please let him just finish his response before he cuts in and cuts off the testimony?
After he finishes giving his response, I'm going to place something on the record, and then we will continue, because I've got a lot of hand gestures from Mr. Grabinski, and unfortunately the recorder can't see you, okay? So that's why I'm paying attention.
Okay, and
All right.
so, and just, excuse me, sir. Before we go on, I just want to make clear that it's my intention, I appreciate the assistance from others, I would like to do it like this. I would like you to explain what happened in words, and then after that, I'm going to ask you to show us what happened. Can you
Well, like I said, he
handle that?
literally picked her right up off the ground.
Okay.
And then his buddy came around and bent over, put his butt up in the air, and he was, I don't know what that was all about.
Okay.
It was the stupidest thing I ever saw.
Let's start, and I'm sorry, we're just going to go back and do this again, if you don't mind. Miss Stolar's in a group, and she's standing there, and then you said Mr. Teuton came and was acting like he was going to give her a massage. Did I understand that right? Why did you think he was going to give her a massage?
Well, he said he was gonna, I said, she dropped her coat down and he was like rubbing her neck and her back, and then all of a sudden he just reached down and grabbed her.
I appreciate that. How far away were you from the incident when it happened?
15 feet probably.
Okay. And so, sorry, did you see it switch from a neck massage, for lack of a better word, to something else?
Oh yeah, real quick.
Okay, and do you believe others saw that?
I don't see how they couldn't. They were all standing. We were actually facing them.
Okay.
You know, she was on that side of the circle and I was on this side. So we were actually, a lot of us that were standing there facing, they saw it.
So
Everybody saw it.
unless you had your eyes closed, everybody would have had to see it. Is that fair?
Exactly.
Okay.
Objection, that's leading.
It calls for speculation, because he said they had to have seen it. Do you know for a fact, sir, that people were actually looking at her, or you said everybody's kind of standing around it?
Well, we were staring at her.
Well,
I mean, unless they,
well, you were
they saw
staring at her, correct?
right.
Okay. So if you're looking at her, how do you know the person over here is looking at her unless you look at them to see that they're looking at her? So I guess, do you know for a fact that the people beside you, as you're staring at her, know that they were also staring at her? Or is it possible they could have had a conversation with the person next to them? I guess I don't understand.
It took, this didn't last 2 seconds. This went on for a couple of minutes.
But you
He
firmly
didn't just
believe.
grab her and set her down. He held her up for a while.
Okay, so it
So
was so
everybody kinda-
abrupt that
Everybody was kind of
you
looking.
saw other people looking at her.
I did.
There you go. That's what I needed to know.
Any other questions, Judge?
No, I just wanted to clear that he did see other people looking at her. This isn't a guess. It's not speculative. He's just testified that he saw others looking at her.
I was here. I didn't leave the room for any reason.
I didn't think you did, but we had an objection from the respondent, so I'm overruling their objection. And just for clarification, he has clearly testified that he saw that.
Right. Okay.
Thank you.
Like I said, his hands were, he was doing this when he was groping.
Would you? Okay, groping. I would
Yeah.
use the word kneading. Is it? You think that's a fair
Well,
description?
Whatever you want to call it.
Okay.
He was having a good time.
Okay. And about how long did this good time for Mr. Teuton last?
Probably a couple minutes.
Minutes?
Because his buddy had to come around and get in front and do his little dance, shaking his butt around and stuff. So it was, maybe 2 minutes.
Okay.
Other
Other
than
than
everybody stopped because it was, everybody was in shock at what was going on.
okay, and if we could just move away from the term everybody, is it fair to say that many people were acted surprised?
Oh yeah,
Okay, and
nobody could believe it.
okay, and do you believe that the Toutant grabbing Miss Stolar's breasts was obvious to other people?
Objection speculative?
And what did they
Hold on,
do to
hold on.
suggest that to you?
Hold on. There's an objection. Speculative. I think he can speak to his own beliefs. He just can't, as to what he thinks and his perceptions. He cannot speak as to what another person thought. So,
Well, he can judge
so,
because
so
they're
I'm
all-
allowing the.
Sure, but everybody there is a party opponent, so he can say what other people. I mean, he can't divine it's in their minds, but he can certainly say whatever they said, how they reacted, and go from
You
there.
can see it in their face when people go,
Well,
you know.
Can I
it's pretty
finish? Can I
obvious.
finish my? I like to make my rulings very clear on the record. He can't speculate, but he can speak to what he believes, what he saw, the demeanor of others, and that sort of thing. So I'm going to overrule the objection and allow the answer.
Okay. Did you hear, other than facial? I guess we'll start that to confirm. You saw other people who
Objection,
weren't.
form of question, it is leading. You saw other people?
Okay, I'm going to ask Attorney Cross to reform the question and just ask him what he saw and to describe the demeanor if he was able to do so.
Okay. Are you able to describe the demeanor of people that weren't Miss Stolar or Mr. Toutant or the other person that we haven't identified yet?
Yeah, like I said, everybody was kind of, to me, looked really surprised and shocked that somebody do that in front of, you know,
And did you see more than one person act surprised and shocked?
yeah.
Okay. Now, if the people that were on that ice at that time told the Department of Corrections that they didn't see what happened, would you think they were lying?
Objection speculative?
And it's asking the witness to speak to the credibility of another witness, and I'm going to overrule that.
Anybody that said they didn't see it, well, either blind or.
When I say overruled, that means you can't answer the
Oh,
question.
all right.
So I'm going to strike that answer as non-responsive. Ask him something else, please.
Okay. So, let's talk about Miss Stolar. Did you hear her make any audible response in terms of what was going on?
No, she did, but I couldn't hear what she
Okay.
said.
Did she make any physical response that you could
Oh
see?
yeah, her eyes got big and she was in shock. She didn't expect that.
Okay. And did you, based on her reaction, did you perceive that those touches were unwanted?
Oh, they were unwanted, all right. She wouldn't allow that.
Okay. Now, did you see the demeanor of Mr. Toutant during this encounter?
I did.
Can you describe that demeanor?
He was laughing he was having a good time. He thought it was funny.
Okay. And did you think it was funny?
No.
Okay.
Especially with people you work with. You don't do that to people you work with. You know, my old man was a battalion commander at 32nd Infantry Division, and I was brought up different, I guess, than these people. You talk to respect people, especially people you work with.
Okay. Do you know how the incident ended? Can you describe that for us?
He took off running. I started to walk over there, and he took off running.
Okay, and that was going to lead me into my next question, or maybe I should ask that first. When you saw the incident, what was your reaction?
If I'd have been 20 years younger, I'd have gone over and kicked the snot out of him. That's what he needed.
Did you advance on him in any way?
Oh, I said they started to walk over her. That's when he dropped her and took off running.
Okay. And when you say dropped her, I think there's some confusion on that. And I think you said this before, so hopefully you can clear this up for me. Was she lifted off the ground?
Objection leading. Was she lifted off
Okay.
the ground? First of
Okay.
all, it's asked and answered, and
Okay, couple things. Yes, the question was asked and answered because the witness already did testify that once started with the neck and back massage, reached around and actually lifted her off the ground, which was one of the things that the witnesses said shocked him. So I think that part has already been asked and answered. I think you could just simply ask him if he has anything else he wants to expound upon based on his earlier testimony.
Great, thank you for those suggestions. And you may recall how I said in that question, I'm not sure if I asked this before, and I pre-apologized that if I had, because I was trying to get clarification of whether I understood him correctly, that he was saying that she got off the ground before, and comparing that with what he just said in the previous question. And I'm going to say that these editing of my questions is, it's getting tiresome. So, let's go back then. I need you to describe, because I've lost all track in my mind now, I need you to describe for us and then show us what Mr. Toutant did to Miss Stolar.
Well, like I said, he slid his hands up under her armpits, grabbed her by the boobs, and lifted her up, and he was groping the whole time and laughing like a Cheshire cat.
Okay.
And I'm like, what? I couldn't even move. I was in shock. I couldn't believe that he was doing it.
Okay, I appreciate that. And I'm sorry for those who had to hear that again. Now, what I'd like to be clearer on, I think, is you start walking towards him, and then he drops her. I understood that part, right? Okay. And then he takes off. Do I get that right?
Yep.
Where did he go?
Out toward the middle of the lake, I said he just took off.
Okay. And did anybody in the circle say anything after that?
No, they were all laughing.
They were laughing too.
They
Okay.
thought it was funny, I guess. I don't understand that either, but
About how many people were laughing at Miss Stolar?
oh, that was 3 or 4 of them.
Okay. And did Miss Stolar appear to be in distress while they were laughing at him?
Well, yeah.
objection, this is misstating the evidence, and it's stating a fact not in evidence. He said that they were laughing. He did not describe them as laughing at her. And now we're talking about them laughing at her, but the at her part is coming out of Attorney Cross's mouth. So it's mischaracterizing evidence that has been testified to. And I think it's also leading the witness into agreeing that they were laughing at her.
Okay. The testimony is that people were laughing. They're approximately 15 feet away. He's at an opposite side of the circle from the complainant. He sees all this happening, so clearly he saw that. And then the reaction was, he's now said about 3 to 4 people in the circle were laughing. So I don't know if he knows exactly what they were laughing at or if they were just laughing in general. So if we could get clarification on that.
Sure. Did you have any, were there any indications as to what they were laughing about?
That was the only thing that happened. I don't know. I couldn't tell you for a fact that they were laughing at her. You know what I'm saying?
Okay.
I don't know what's in their mind, but
Were they, what
it
way
seemed
were
to be
they facing?
acceptable behavior. Let's put it that way to a couple of them. They thought it was funny.
Were they facing towards her when they laughed?
Well, no, they were all, like I said, we're in a circle and we're all kind of looking at each other, so it's, but they seemed to think it was funny.
Okay. Now, out of the other 28 or so people that were there, did a single person stand up for Miss Stolar?
No,
Okay. Did anybody say that was wrong? for example?
No, that's it. It just seemed like it was acceptable behavior to them. I don't know, maybe it's because I'm old, but you don't do stuff like that.
When Mr. Toutant ran, did anybody run after him?
No,
Did anybody go with him?
no.
Okay, how about the other person that was, and I guess I need to be clear on that. There's another gentleman, or I'll say there's another person there, and he's waving his butt. Is that right?
Yeah, his buddy, I don't know his name.
Okay,
But-
how is he waving his butt?
See, he bent over all the way, and then he had his ass right in front of her, kind of dancing.
And this is while she's off the ground?
Yeah,
Okay.
it's almost like they planned it. You know, I don't know why somebody would do that if you didn't know ahead of time you was going to do it.
Thank you. So, is it your testimony that the butt shaker is moving into butt shaking area while the boob grabbing is going, the massage is
As soon as he grabbed her, he came around the front and got his ass up in the air and said he was doing
Okay. And, okay.
Those two must be friends because the two of them were hanging around together the whole time.
Before the event, the
Yeah,
incident? Okay.
all during the event, yeah.
How about afterwards?
Afterwards too. Like
Okay.
afterwards, they came over to the table and right in front of me asked her to show her tits. I'm like, what?
Okay.
And
Was this other
they
gentleman?
thought
Uh-huh.
I was her dad.
And why is that?
Now, why would you? Because that's what she told him.
Okay.
Why would you do that in front of somebody's dad? You know what I'm saying?
Would
I
that
know
be-
why you do that anyway, but unless you're a biker, show me your tits. Show me your tits. I'm like, what?
Okay, and we'll get to there. So, how do you get from the ice to somewhere else?
Well, she got a ride. I walked.
Okay. And when did that end? Quick? Was there still fishing? What happened after the incident?
Yeah, it ended pretty quick after that.
Okay. Okay. How did it end?
Pardon?
Did people just start walking?
Well, it was over. The tournament was over.
Okay.
It only lasted so long. I don't remember the exact time that they quit, but then everybody went up to the bar.
Okay.
And
And
they
then,
gave out prizes and stuff.
so you walked from the ice to the bar. Then what happened?
I went in and had a drink. The guy at the bar, I got talking to him, and he said he made a pretty wicked, I can't remember what it was, but anyway, Manhattan.
Okay.
I told him I liked Manhattan, so he made me one. It did, it was good.
Okay. And then, do you ever learn the name of the butt shaker guy?
No,
Okay. And so at some point you're in this bar, fair?
great.
Okay. Where is Joanne at this time?
Well, she was at the bar when I was at the bar. She was down the bar further.
Okay.
I didn't see what exactly, you couldn't see through all the people, what she was doing down there.
Okay.
And I was, like I said, I was talking with the bartender. And
Did after the Jason Toutant grabbed Joanna Stolar's breast, did you talk to Miss Stolar at all?
yeah, I couldn't figure out what the hell was going on there.
What was
She couldn't figure it out either. She didn't know why
Okay.
that happened.
And what was that conversation like?
Well, I just, I'm like, what was that? And she didn't know. She didn't know why he did it.
And what was her demeanor after the?
Well, she just kind of shook up afterwards. I mean, people don't do that to you every day.
No.
She's just not that kind of a person.
Okay. So you're at the bar, and this is, I understand there's a second incident. Let's get to that in a second here. Did you hear anybody make any sexual remarks about Joanna Stolar in the bar?
No. Like I
Okay.
said, I was busy talking to the bartender and then one of the other guys that was there that I met.
Okay.
We were talking and I wasn't paying attention.
And there's a second incident?
We were at the table. We sat down That's after they handed out the prizes and stuff. We were sitting at a table, and those two clowns came over, Jason and his buddy, and it was, show me your tits, show me your tits. I'm like, get out of here.
Are you at a table
Yeah,
then?
we're sitting at a table.
Okay, is anybody else there?
No, there were just the two of us.
Was this at the bar?
This is not the.
Okay.
Okay. But there are other people in the room, obviously.
Yeah. Whether, I don't know if anybody else heard it or saw it, I wasn't paying attention.
Okay. And so was it just one of them made this comment, or did both of them, or how did this go?
Jason was the one who made the comment. Anybody was just sitting there laughing, but yeah, he's the one.
Okay. And the comment was what again?
Show me your tits, show me your tits.
Okay. And what, if anything, did you say at that point?
I told him to get the hell out of there.
And how did they react to that?
He just laughed and walked away.
Okay. And again, it's your understanding that they thought you were her father.
That's right.
Okay. What did you do after that?
Well, I was talking to her about leaving before that, so then we left.
Okay. And was the request to see her breast, was that one of the reasons why she left at that point?
Yeah. Oh, it was over. Yeah, the party was over.
Okay. When, did Miss Stolar say anything when, was the DOC people asked to see her breast?
Well, she said they've been doing this at work all the time. So, yeah, it kind of confirmed it.
Okay. Did she say that she had complained about it before?
She said before the tournament even, she complained about it. She
Okay.
told me it was going on, and she said they wouldn't quit.
Did she say whether or not the Department of Corrections did anything to resolve her complaints?
No.
And I'm sorry, when you say no, did you mean that they know they didn't, or no, she didn't say that, or something else?
I'm not really sure what, I don't recall exactly what she said about it, but it was, the general thing was nobody did anything.
Okay. And are you aware of there being any, let's say, law enforcement involvement afterwards?
Well, I got a phone call from, after she filed a complaint, I got a phone call from investigators about it. They asked me about the incident, and I told them pretty much what I told you guys.
Do you know where those investigators came from? Were they DOC or something else?
They were, they were DOT people, like whatever organization investigates stuff like this.
Okay. Well, did you talk to law enforcement?
No, I don't know if they were law enforcement. They told me she told me they were gonna call. They were some kind of they were investigating the incident.
Okay. And,
I'm sure they recorded it.
okay. And I guess what I'm trying to understand is, do you think that you talked to the sheriff? Do you think you talked to the Department of Corrections, somebody else?
Sounded like they were internal. I don't think it was the sheriff's department.
Okay.
It was some kind of internal. They got an internal affairs there. That's the way it sounded to me, that they were.
Okay. I'm going to show you what's marked as Exhibit 10.
ERD number, please.
Sir, there's a number at the bottom of that page. Can you say that out loud? In bold and black.
096.
Thank you.
I don't have my glasses, so this is going to be kind of a.
I don't need you, well, I guess
I just need to know what the Bates number is.
I thought you said 96, Judge.
I don't.
Oh, the solar one? Solar one, 001003. I gave you a big number before.
Great. Are you able to read that? Or is that too small? Or?
It's just pretty hard for me to read it.
Okay. Just give me a second.
Oh, cool. I can read it now.
What's the Wi-Fi password again?
Oh, it changed today is, I think it's racing with a capital R, 1 Mexico.
CW students will steal your internet in a second if you allow it. Okay.
Is that why they do it? I don't know.
So IT has. Have you seen that document before?
This one?
Yes.
No.
Okay. Does it refresh your recollection of whether or not you talked to the Department of Corrections though?
Like I said, I don't remember who the people were,
Okay.
but I thought they said they were internal affairs, but it was on the phone. And then there was, she had an interview on a computer with somebody from, was that the sheriff's department? Anyway, or the DA or somebody, and as soon as they found out I was in the room, apparently they didn't know I was there.
Right.
And as soon as they found out that was the end of it, apparently she didn't want to witness to whatever she was saying because she shut off right away.
Who are you talking about?
Remember that when?
Hold on, sir. You can't ask your question.
Oh,
Okay. But let's then, because I'm confused, but let's just back up
Yeah.
for 1 second, and I think we can get to there. So, in the document that you just read, and were you able to read it?
right.
Okay. Does that sound more or less like the conversation that you would have had with the investigators?
Yes.
Okay. And can I have the document back?
Okay.
Just hang on to him just in case.
Are you going to use that document next?
Yes. Sorry, Judge.
Okay, have marked that as Complainant's Exhibit 2. It is ERD Bates number 1003 through 1006. It is the investigatory interview, is how I've titled it as a description, of Mr. Stephen Jerbinski. I have marked it. Attorney Hitchcock Cross, are you offering this into evidence, sir?
Yes, Judge.
Any objection from the respondent?
No.
Hearing no objection, it is admitted. Please continue, Attorney Cross.
Okay. So I'm just gonna ask you if this sounds familiar to you. But the question here is from them is, what did you witness between Jason Toutant and Joanna Stolar? And the answer, as I see it, is I watched him. He looked like he was giving her a neck rub or a shoulder rub for a second. He got his hands on her shoulder, and also he reached up and grabbed her by the boobs and dang near picked her up off the ground. He started fondling her, then he let go. Apparently he thought it was funny. And, okay, and are we clear on this, it may seem minor here, but are we clear on this point about whether she was off the ground or if it was near to off the ground?
She was off the ground.
Okay. And again, you gave, when you talked to the investigators, did they identify themselves?
Yes.
Okay. And do you now believe, based on this document, that they were from the Department of Corrections?
Like I said, I'm not sure exactly if they were from the Department of Corrections. I guess I wasn't sure if they were internal investigators or,
Okay.
but they identified themselves as investigators.
Okay. And is it also true that you gave a statement to the police, for lack of a better word?
I don't remember if I did or I didn't.
Okay. Do you think you gave more than one statement?
I only remember the one on the
Okay.
telephone.
Great. Okay. And so I just keeping going further. Did you tell the? And this is based on what I'm reading here. This would have been somewhere on March 11th of 2020. Does that sound about right when you talked to them?
Right.
Okay.
I was walleye fishing at the time down in the river by.
And you tied your own lures for that?
So I had to quit fishing. They had to call me back because I was on the river and I went to the truck so I could hear.
Got it. Okay. So, is it true that you told the Department of Corrections that Miss Stolar's reaction was shock? She was like, "Holy crap! Yeah," she wasn't expecting that at all.
Oh no, she wasn't expecting it.
Okay.
They could see her face was just like, wow.
And is it also true that you told the Department of Corrections investigators that Teuton's hands were on Joanna Stolar's chest for at least a minute?
Yep.
Okay. And it's also true that you told the Department of Corrections investigators that he meaning Teuton, reached up under her arms and then he damn near picked her up off the ground.
He did pick her up off the ground.
Okay. Is there a reason why, just to clarify in case it comes up later, that you said he damn near picked her up off the ground as opposed to he did?
Yeah.
And what's that reason, if you can explain it to us?
I don't know.
Okay. And it also says in here that you thought you were the only sober one on the ice and that everybody was drinking. That part's true, right?
Everyone I saw had a drink in their hand. Either a cup or a can of beer. A lot of them were drinking beer.
Okay. And when the Department of Corrections asked you, do you believe that it was intentional for Mr. Teuton to touch Joanna Stolar in that manner? Is it true that you said, "Oh yeah, I mean that's what he set out to do. I could just tell by the way he acted"?
He did it on purpose. It was no accident.
Okay. And when did the Department of Corrections investigators tell you what they were going to do with your statement?
Like I said, as far as I know, they recorded it.
Reported it or?
Recorded it.
Oh, recorded. Thank you,
Yeah.
sir.
There was two of them, but only the one talked. But I thought they said they were recording the statement.
Okay. Is it also true that when asked about what was Mr. Teuton's demeanor after it occurred, that you said he's all cocky and smart alecky and thought it was great fun?
Oh yeah.
Okay. And it's also true that you told the Department of Corrections investigators that you believed that he was doing it intentionally because he was smiling, laughing, and joking about it.
It was intentional. There was no mistake in that.
Okay. And they asked you at the end, I believe, if you had anything that you had any questions for them. Do you recall that?
Not really, no.
Okay.
That
Well,
was quite a while ago.
does it refresh your recollection if it says, no, I guess not. I mean, I'm just happy that you're doing something about it because, like I said, it's kind of bullshit. And the fact that she already had a problem and now it happens in front of God and everybody and nobody did anything, that really amazed me. I can't believe nobody took any action. It took this long, and I would have thought that there would have been immediate action and not, some kind of reprimand, but. Okay, and is it true that the investigator shared her frustration?
That's exactly what I told them.
Okay. And then I see it here as saying, I mean, she's a good kid. I've known her for quite a while now. She fishes and hunts with me all the time, and she's like a daughter to me. She's not that kind of person, and she worked really hard, She's a single mom. She's worked really hard to get the job she's got, and, she's been doing really, really good, and I'm proud of her. And then to have this shit, that's kind of rotten. Does that sound about what you said?
Yep.
Okay. And is that your feelings today?
It is. I still have no respect for any of them people. I can't believe they would let that go on and not do anything about it.
And after you told the Department of Corrections this, did anybody ever contact you again from the
No.
Department of Corrections? No.
Not that I recall.
Do you have any idea of if Mr. Teuton was charged with a crime?
Not that I know of. Well, they did something. they did do something later on, but it took a long time. I think he got probation or something out of it.
Okay. Would it surprise you to learn that he was originally charged with a sexual assault?
No, pretty much what it started out as.
Okay. Would it surprise you to learn that the sexual assault was later reduced to a disorderly conduct?
I didn't know that.
Oh, okay. And do you believe what Mr. Toutant did was disorderly conduct?
No, it was a sexual assault. You can't, I don't know how you justify making it a mistake. No, that's not right.
Okay, and there's no question in your mind that Toutant was touching the sexual organs of Miss...
Objection leading and asked and answered.
I didn't finish the dang question.
Okay. One, he didn't finish the question, so don't answer the question yet, sir. Attorney Hitchcock, could you finish the question first?
You gotta cross the T's and dot the I's.
I guess sometimes you do,
Yeah.
right? Somebody grabs your boobs and then you gotta cross the T's and grab the I's, right?
Okay.
Gotta be
Let's,
legal.
all right, we're not gonna have commentary, please. It's not appropriate. I just would like, before I make a ruling, to actually hear
Oh,
what...
I'm not gonna repeat the question.
Okay,
So you
All
can
right.
rule however you see fit.
well, there's nothing to rule on because the question's been withdrawn.
Oh, I didn't say that.
Well, it wasn't answered,
Okay.
so you can either ask a different question, rephrase it, but I'm certainly not gonna make a ruling on a question that has yet to be
Great.
asked.
So, are you aware of whether or not Mr. Toutant ever contacted Ms. Stolar again?
No, I don't know.
Do you believe Mr. Toutant ever apologized?
Objection speculative.
I don't know.
Okay. Now, when you were at the bar, did you see any DOC employees that were intoxicated?
Well, everybody was drinking. I don't know how intoxicated they were, but everybody on the ice that I saw was drinking something.
Okay. And other than, for example, the comment about can we see your boobs, was there anything else that DOC employees at this tournament might have done to indicate that they were intoxicated?
Not that I recall.
Nobody was slurring their speech?
Objection leading.
Well,
That is leading, just rephrase.
it's a typical bar scene. Everybody was,
And did
pretty
it,
much having a good time. I didn't see anybody overly intoxicated.
okay, and were
Them two kids had plenty to drink, I can tell you that. They were rowdy, but they're young.
and did
The
you
rest
see
of the
any
people
other
older.
excuse me, did you see any other DOC employees leave the bar at any time?
Well, yeah, people were coming and going to the bathroom and whatever, and like I said, I wasn't paying attention. I was at the bar talking with the guy, there was a bartender, and there was a couple other people there I was conversing with, so I wasn't really paying attention.
And so when you left, did you expect, when you left, did you see anybody else leave at that time?
I don't recall.
Okay.
There was some gal came over when she found out I was taking her home, and came over and says, "You can leave her here, we'll take care of her." I says, "No," I says, "I see how you take care of your people." I says, she's going home.
Do you know who that person was that you talked to?
No, I don't remember. It was a woman.
Was she younger or older by your previous definition?
Like I said, everybody's younger than I am.
Right.
I would have said maybe 40s, 30s, 40s. I wasn't really paying any attention.
So you drove her home. That's what I'm asking.
No, I followed her home.
Followed her.
I had her follow me,
Got it.
is what I did.
Now, based on your knowledge and experience in life, and also what you saw at the fishing tournament, did you believe that Joanna Stolar did anything to suggest to any DOC employees that it was okay to go grab her breast?
She would never do that.
Okay. And not only would she never, you didn't see her do any of that,
No.
right? Okay. And do you believe that she was particularly provocatively dressed during that time?
No, she had a sweater on that was like this thick. I mean, it was a heavy, she was dressed for ice fishing, then she had a heavy coat on too yet.
Okay. I got a question for you. It's simply this. When Mr. Toutant came back into the bar, did anybody say anything to him at that time?
Not that I know.
And he was allowed to participate in the activity after all that happened,
Yeah.
right?
Like I said, everybody thought, everybody was having a good time, and apparently they all thought this was fine. Nobody
Okay.
said anything.
And let's talk after that. Did Joanna complain to you about how it felt to work at the Department of Corrections after that had happened?
Well, yeah, they had her, he's a sergeant, so they had them working together, which is kind of, I don't know.
And when
Doesn't
did
make any
she,
sense to me, but whatever, you know.
when did she tell you that they had them working together?
It was a while afterwards, not real long afterwards, after the incident.
Okay. And did she tell you how she felt about that?
Well, she was uncomfortable, but it's work. You gotta do what they tell you.
You got to do what they tell you.
Like I said, the supervisor to supervisor, if it's,
Okay.
You don't have much to say about it if they tell you this is what you gotta do, this is what you gotta do.
And did she tell you how that made her feel about continuing to go back to work?
Well, she was uncomfortable, yeah.
But you got to go back. You got to do what they tell you,
Oh,
right?
she's a single mom, she's gotta work. I said she liked the job itself.
It's just the boob grabbing part you got to
Well,
done.
that was nonsense.
Objection leading?
Okay. And after the two gentlemen, I'm sorry, scratch that. After the two DOC employees asked to see her breast, did anybody throw them out of the party at that time?
No,
Was there any repercussions of any kind?
no.
Okay. I have no more questions. I do, though, before we start a new section. I note the time. I also recall that we had some provisional agreement to have Carrie Beyer testify at 1 o'clock, which maybe we want to address sooner than later, given the timing. I'm flexible in almost every regard, but I wanted that to be noted.
Thank you for reminding me. Because that was 3 pages or 4 pages, 5 pages back in my notes.
That's why I don't keep notes, Judge.
Huh?
That's why I don't keep notes, Judge.
Well, I have to. I'm old. Okay, so that is correct. We're going to have somebody else testify out of order at 1. We already agreed to that. It's 12:15 now. Obviously, Attorney Hitchcock Cross is done with you right now, but they now get to ask questions. They being the respondent. So this is what we're going to do. How long do you think your testimony is going to require?
From Carrie, what do you think, half hour direct?
Okay, so that's going to be at 1. Is it amenable? Are you local? Are you nearby? Did you drive 50 miles?
Watertown,
I don't know where that is.
35, 40 miles east.
But I can also explain, I think, and you'll excuse me for interrupting, that I think you're stuck here for the duration of today.
Yeah, because I rode with her, so.
Oh.
Based on that consideration.
Unless I
Okay,
want to walk.
okay, all
Or I
right,
can
all
find
right.
cars.
So we'll get back to your testimony later this afternoon. I'll remind you you're still under oath. Obviously, Ms. Stolar's here, so she's heard all of your testimony, but please don't discuss it with anybody else. Why don't we break for lunch? Everybody take a bathroom break, whatever. Let's be back at 1 o'clock, and then we'll proceed with your witness, have cross-examination by Attorney Hitchcock Cross, and then we'll probably take another 10, 15-minute break to give everybody a chance to find you. I don't expect you to just live out in a hard chair, okay?
I ain't got nothing else to do.
I know, but I'm sure you have his cell phone or something, or you can contact him in some kind of way, say, hey, it's going to be another half hour, or get ready to be here. If you guys can communicate in that kind of way, if he wants to go get something to eat or spend a little longer.
He seems like he can handle himself.
Well, I just don't want him to think he's forced to wait in this, because I don't want you to feel that way, sir. Okay?
I'm good. Like I said, I was in the Army. I'm used to waiting.
I was going to say that for him.
All right. Well, why don't we do that? I'm going to go off the record now, and we will reconvene at 1 o'clock.
Could we have a full 45 minutes?
Full.
If that's,
It's your witness, it's no problem.
Yeah.
okay.
Oh.
12
I
right
need
now.
some time here.
That clock's off.
Okay.
All right.
Oh, yeah. I mean, it's 12. It's 12. Is that is enough? You can have an hour. We can go till 1:15. Whatever people think they need. What are the thoughts? Be back at 1 or 1:15?
1:15 is.
Let's do 1:15. Will that work with everyone?
Everybody loves this good place to go.
Okay.
I need a winning lottery.
Okay. Good afternoon, everyone. We are back on the record in the matter of Joanna Stolar versus the Department of Corrections. Again, the case number is CR 2020-02513. The appearances are the same. We do have a respondent witness that the parties have agreed, and I have no objection to calling out of order, shall we say. And that would be Miss Carrie Beyer. Miss Beyer, before we get started, if anybody asks you a question and you don't understand or it's confusing or you can't hear it, please let us know. When you're asked a question, if you know the answer, please give the answer. Don't guess or speculate. It gets kind of confusing, and then we end up with 53 more questions trying to figure out whether you knew it or whether you're guessing. Again, if you need something, if you don't know, you don't know. That's an acceptable answer. Don't recall acceptable answers. But please ask, because when you answer, everybody's going to make understandings that you knew what the question was asked. And if you hear somebody make an objection, stop. Let that person give their objection in full, and then I'll hear from the other side, and then I'll make a decision and let you know whether you can answer the question or not, okay? Any questions so far? Okay. If you could please raise your right hand. Do you affirm or swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. And could you spell your last name for the record?
Beier.
Thank you. I don't know who from the respondent is calling this witness and who will be questioning.
I will be Attorney Zakar.
Okay, thank you.
Excuse me, thank you. Good afternoon. Could you please tell us how you're employed?
I work for the Department of Administration, and in a shared services environment, I am assigned to be the HR director at the Department of Corrections.
And in terms of you being the HR director, do you oversee of any other staff?
I have a large team. We have approximately 110 to 120 in the Bureau. I'm responsible for payroll and benefits, for employment relations, for the Office of Diversity and Employee Services, for recruitment, staffing and selection, and class and comp, and then also all of the institution or division HR leadership or HR offices roll up to the bureau as well. So I'm responsible for anybody that's in a field office.
And if you know, approximately how many employees work for the Department of Corrections?
We have a lot of vacancies right now, but we could have up to 10,000 employees.
And when did you start working for the Department of Corrections?
Objection, states facts not in evidence.
I think she already stated she works for the Department of Corrections.
I heard administration, maybe I heard something wrong.
I'll rephrase it.
Well, no, we don't need to rephrase it. Testimony was that she works for DOA, however, she has a shared job that encompasses her being over DOC as well in terms of HR.
Okay,
So she also works for, she's in charge of HR at DOC.
I didn't get that.
Okay, can you, well, then, why don't we start from the very first question? What is it you do and who do you work for?
I'm technically employed by the Department of Administration. However, there is a shared services environment for HR, and so my job is to be the HR director at the Department of Corrections. I'm assigned to the Department of Corrections.
That's not, I didn't hear 4, I heard assigned 2. I work for the Department of Administration assigned to the Department of Corrections. It's not, it's not the same thing as I'm sure we'll find, and that's why I made the objection, as I work for the Department of Corrections.
Next question.
Have you ever been employed as a Department of Corrections employee?
Yes.
When was that?
Right out of college, I was an HR specialist, and then in central office, and then I also was the HR manager at Prairie du Chien, or institution HR director at Prairie du Chien Correctional, and then in 2011, I came back to my to a similar role to what I do now. It was just prior to shared services, where I was the director of HR for Department of Corrections and employed by Department of Corrections.
Okay. I'm going to ask you if you could please just slow down because I'm trying to take notes.
Yeah, sorry about that.
Okay.
Where do you want me to?
You're good. Just going forward, please.
Okay. In 2018, we became a shared services environment, and so I was technically employed by Department of Administration starting in that year, but my role remained the same at Corrections.
And I don't know if you indicated what year you started out of college. What year was that?
Dating myself, it was 1998 when I started with Corrections.
And where did you work out of college back in 1998?
I started with Department of Corrections at the central office, doing staffing and recruitment and class and comp work as an HR specialist. I then went to Prairie du Chien Correctional as an institution HR director.
What year was that?
In 2000.
And how long, or were you at Prairie du Chien starting from 2000 until when?
Until 2003.
Okay.
And then I went to UW La Crosse.
What at La Crosse?
UW La Crosse, University of Wisconsin La Crosse. And I worked for the UW system until 2011.
So you came back to the Department of Corrections in 2011?
September of 2011.
What was your job title in 2011?
I was the HR manager for Department of Corrections, the director of the Bureau of Human Resources.
Is that the same title you have now?
Under shared services, my title changed to executive HR manager, still the director of human resources.
Have you been in the same title since 2018?
Correct.
Were you been employed, I took it, in 2020
Yes,
in the same title?
yes.
And are you familiar with, well, actually, let me back up here. Could you please tell us about what types of, let me strike that. What, are there any policies or procedures that you follow as part of your job duties?
So all of the human resources procedure, or policies and procedures would be my responsibility to enforce, make sure that the Department of Corrections was following, work with them if we needed to make updates. That would all be under my purview. So there are a number of HR policies or executive directives related to human resources.
Now, are there also, now you said there are policies related to human resources. Are there policies that are specific to the Department of Corrections?
Yes.
Okay. So these specific policies for the Department of Corrections, are they based upon some other policies?
So in the state of Wisconsin, the Department of Administration, Division of Personnel Management has human resources handbook chapters. Those are to make sure there are procedures and policies that follow the statutes, the administrative code. All state agencies are required to follow these HR policies. Then each agency can create their own specific policies, provided they comply with the enterprise-wide, statewide policies.
Thank you. And could I please have you, if you could take that binder that's in front of you, and under the tab for number 2, it says Respondents Exhibit 2, and it starts on page ERD 1113.
Okay.
And it goes to page 1127. Could you please look at that?
What exhibit is that, is yours?
It said it was Respondents Exhibit 2.
2.
Okay. And the ERD number, please?
1113 is the starting page, which is the blank page with the title.
All right.
So if you want the page where it starts,
Yeah.
it's 1114 through 1127, which are the top numbers.
1114 through 27. 1127. I'm going to mark this as Respondent Exhibit 1. Bates number ERD 114 through 1127 as Wisconsin HR Handbook. It's been marked. Are you offering this? at this
Yes.
time?
I would, unless I need to establish if she recognizes it or not.
Oh yeah, I'd like some foundation.
Okay, let's do that first.
Could you please review that document, let me know if you recognize it?
Yes, I do recognize it.
Could you tell us what it is?
It's the statewide chapter, which outlines the employee work rules that all state employees are under, and also the disciplinary procedures for state employees.
And does that document have a name?
It's Wisconsin Human Resources Handbook, Chapter 410, Employee Work Rules and Discipline Procedure.
And is this a document that you typically rely upon in your duties with human resources?
Yes, this would be the statewide policy on work rules and discipline. And then again, agencies create their own policies off of this.
At this time, I'd like to offer exhibit number 1 for the respondent into evidence.
No objection.
Okay, the exhibit, again, will be Respondents Exhibit 1, ERD 114 through 1127. The description I'm going to give it is Wisconsin HR Handbook, Chapter 410. It's been marked, it's been offered, and without objection, it is now admitted. Thank you.
Thank you. Ms. Byer, can I also direct your attention to the tab that's number 1 in that binder? And you'll have, it is marked 1102 through 1112. Could you take a look at that document and see if you recognize that?
Yes, I do.
And what is that document?
This is the DOC specific policy on employee disciplinary investigations. So we in my office would be responsible for creating and maintaining this along with Department of Corrections.
And does this document have a title?
The description is Employee Disciplinary Investigations, policy number 200.30.304.
No objection.
Okay, I'm going to mark that as Respondent Exhibit 2. It is ERD 1102 through 1112. It's been marked, it's been offered. Hearing no objection, it will be admitted. The description I've given it is DOC specific HR policy, employee disciplinary investigation.
Thank you. And if I could just ask you to look at one other exhibit, this would be under tab number 3. It starts with the number at the top right is 1129 through 1152. Do you recognize this document?
Yes.
What is this document?
It is the Wisconsin Human Resources Handbook, Chapter 412, and it covers investigation and predisciplinary or Loudermill procedures.
And I'm sorry, did you say, you said it was investigation and predisciplinary Loudermill procedures. Is there also a chapter number on that?
Chapter 412.
Thank you. Is this also a policy that you rely upon in your duties with human resources?
Yes, for investigation, for disciplinary matters, this handbook chapter applies to all state agencies and state employees, so we have to follow this.
I would like to offer this as Respondents Exhibit 3.
No objection.
Okay, hearing no objection, this will be marked as Respondents Exhibit 3, ERD base number 1129 through 1152. Again, it's been marked, offered, and admitted without objection. The title is going to be Wisconsin HR Handbook Chapter 412.
Thank you. So, in your role, do you have any particular duties or things that you do if there is some discipline that's done in the department?
Yeah, so my, in accordance with the statewide policy, either the director or HR director or their designee must review all disciplinary matters, go through different procedures prior to discipline. For my bureau, since we have so many, I have an employment relations section that reports to me. So I supervise the employment relations section. They are the ones that work with the divisions or the Office of Internal Affairs to get everything ready. At the time it is ready to proceed to a disciplinary stage, that's when I would be involved.
And what exactly would you do then when you become involved at that point?
Once a discipline, depending on the level, but once a discipline is ready, if it's a high profile, it's an off-duty, it's a harassment, it's a skip in progression, it goes to a management advisory team. That team is made up of me, the Employment Relations Program Officer, Office of Legal Counsel, and the Office of Diversity and Employee Services, and the Office of Internal Affairs. We would review the case, and then it's my responsibility to take a recommendation from that team to the Office of the Secretary for the cases that have to go to the Office of the Secretary.
So, in terms of taking the recommendation, is there a way that you record those events?
So we get summaries to review for the Management Advisory Team, or MAT. It's sometimes referred to as MAT. When we have that, we get a summary of what happened, and then there is a routing slip that I will sign off on once we've had the MAT meeting, and also once I've met with the Office of the Secretary. So I do have a signature line on a routing slip.
So, when you indicate you are reviewing summaries, where does that summary come from?
So I have access to the entire packet because Employment Relations reports to me, but the members of the MAT team don't necessarily need the entire investigation. They can sometimes be hundreds and hundreds of pages. So there is a summary that is created by Employment Relations specialists or program officers that report to me, and it's a summary of basically the findings of the investigation. They will present that at the MAT meeting to the members of MAT.
And so, once you've done that, then you take that information to the Office of the Secretary?
I have a weekly meeting with the Office of the Secretary. Either all three, the Secretary, Deputy Secretary, and Assistant Deputy Secretary, or for sure the Secretary if the other two are not available. I have a meeting weekly with them where I go over the summary and we discuss, and then a decision is made.
Excuse me, just for clarity of the record here, when you're saying them, is that referred to the secretary or to that entire group?
I can clarify that.
Please.
Can I can do that? Okay, so, I don't know, did you finish your answer?
I think, I'm not sure.
Okay, so, could you, now you said you have a weekly meeting, and it's the secretary, and it also could include the deputy secretary?
Correct. And the assistant deputy secretary.
Are all three of those individuals there for every meeting?
Not necessarily. It depends on their schedule. So I have a standing meeting with all three of them, secretary, deputy secretary, assistant deputy secretary. But they're not always all available. So I meet with who I can.
So earlier you had indicated there's like a routing slip. So when you meet with the office of the secretary, is there a way you indicate who's at that weekly meeting on that slip?
Yes, I would indicate, so it varies, but if I meet with all three of them in person, I would say I met with OOS leadership. If I meet with all three of them over Teams, I would reference I met over Teams with OOS leadership. If any of them are absent, then I list who I met with.
I have a question, just because I don't know any of these acronyms.
Oh, I'm sorry.
No, don't apologize. I have no problems telling people that I don't know something. When you say I met with OS, what does OS mean?
Office of the Secretary, so on the slip, instead of signing Office of the Secretary, I will just write OOS leadership. If it's
And that's
all
the
three.
Office of the Secretary of...
Department of Corrections.
Thank you. Okay. That was it. That was my only question.
Okay, thanks. All right. So let's double check here. So do you remember a disciplinary case for a person by the name of Jason Toutant?
Yes.
So do you recall what year that was?
2020.
And was that the only case that you reviewed in 2020?
No. No.
Do you know how many cases you reviewed in 2020?
I don't. It's hundreds. Today I met with the Office of the Secretary and I went over probably 10 to 15 cases.
And I think you had explained earlier that you do review the summaries, but not the entire packet. Was that accurate?
Yes, I review the summaries with the Office of the Secretary leadership, whomever can be there at the meeting. I do have the packets available to me. Oftentimes there are follow-up questions or things that they ask me, so I have the materials there on my computer to ensure that I can answer questions.
And I just wanted to clarify something you had discussed earlier, that you'll review discipline records depending on the level, and you had mentioned some different things. Could you, I think one of the things you had mentioned was a skip. What does that mean?
So if there's a skip in progression, we don't have the authority even at the Department of Corrections to approve skips in progression. Those would have to go downtown to the Division of Personnel Management. So anything that requires or that is being recommended for a skip in progression, we review at the Office of Secretary level.
Could I get somebody to define these terms? I realize everybody else here may be aware of them, but I want to make sure I understand. Again, I apologize for interrupting. What is a skip and progression?
So in the state of Wisconsin, we have to take progressive disciplinary action.
Okay.
So follow the progression. It's outlined in the handbook chapter. I think one of the ones we just
One of the
submitted.
made all up? Okay.
Yep. So there has to be following progression unless there is a serious act of misconduct. And a serious act of misconduct, 9 of those are referenced in statute. And then we have 5 more for the Department of Corrections in one of our executive directives that also
5 more?
5 more that could also be a serious act of misconduct. That's defined by policy and supplements the 9 from the statutes. It is statutory that we can only skip progression if there is a serious act of misconduct that someone is found to be in violation of.
Thank you. Thank you.
Yep.
Again, I apologize to everyone, but I have to understand with the terminology, otherwise we're speaking in different languages.
I'm sure I was in the same position at one time.
Yeah, well,
Sorry, I gotta find my spot. I was in.
I'd rather not guess. I'd like to know exactly what it means.
So, sorry, I can't see the screen. So you had also mentioned something regarding off-duty. What did you mean by that? If you could explain off-duty.
So if there's off-duty misconduct that someone does outside of the workplace, if they are being investigated, those would come up through the management advisory team and the office of secretary for a determination.
And so, are those common occurrences in general?
We have some, I can't say if they're more common than anything else, but we do have a lot of employees, and sometimes things happen in the community, and so yes, it does happen on occasion.
And just getting back to Mr. Touton's case, did his case fit within either of those categories you just discussed?
Yes, he was facing off-duty charges, I believe originally criminally and then ultimately locally. So his case was reviewed.
And do you recall what the ultimate recommendation was in that case?
Progression, which was a 1-day suspension.
When was that decision finally made?
I believe December of 2020.
Do you recall when the incident, the basis of that discipline was?
January 27th, there was an incident. I don't remember when he was charged. I believe in February, but I don't know the exact date.
And do you know why it was a number of months before that final decision was made?
The investigation can often take several months if there are a lot of witnesses involved, so that part of the process is largely outside of my control. In this case, I believe we also waited to see what was going to happen with the criminal charges.
And so, is there, so Mr. Toutant, do you recall if there were any other consequences that came about in addition to the 1-day suspension?
Can you rephrase? Or
Yes,
clarify?
I can rephrase that.
Or clarify.
Did it, so you had mentioned that you thought he was charged in February. What, if anything, happened after the department found out about that?
Oh, when he was charged. Okay. We placed him out on administrative leave pending the outcome of the investigation or resolution of the outside charges.
Do you recall if he was permitted to return to work at any point?
Yes, I believe, well, I know his case was extended at least once, and so we brought him back to work and placed him at a different facility so that we weren't continuing to pay him to sit out, since the delay was happening on the criminal charge side, and we have to pay employees who are on administrative leave unless there's something we can point to not pay them. And so we felt like getting him back to work was appropriate, just not at the same facility.
Why not at the same facility?
Just because the investigation wasn't complete, we hadn't made a decision yet, and so we felt it was best to place him at another facility in the area until we had a resolution.
Can I ask you to look in the binder again for, it's under tab 12, and it is pages, it is page 1380 at the top right. Do you recognize that document?
Yes.
What is that document?
This is our disciplinary action routing slip. So this is where several individuals sign off on what the recommended action is for an investigation.
So we're going to object to this document as untimely filed. We received this after 4:30 on the cutoff. This is my understanding, it's Exhibit 12 here. And so based on your rules of strict compliance and the pre-hearing order, we're going to insist that this not be discussed.
And if I can respond to that one?
You can respond, of
Okay.
course, and then, hold on, I want to note my objection and write it down for the record. So this would have been, it started on page 1380 until, is it just 1380?
Yes, it's a 1-page.
That's a 1-page, and that is a disciplinary routing slip, is that the name of it?
Yes.
Okay. All right. You may respond, and then I will respond.
Okay, just a second. Somehow I'm having first of all, DOC attempted to file that. We would be glad to have somebody look, one of the state tech people do a forensic examination to find out to determine when Stephen Ross here attempted to upload them into the portal and into the Dropbox and was unsuccessful. Let's say, for example, that on the very day that Timothy McVeigh blew up the Oklahoma City courthouse, somebody was supposed to go to court. They're supposed to be sentenced on something. Are they going to be charged with bail jumping for not appearing in court because the building wasn't there to appear? We've got this situation with the documents not being uploadable into the portal. Moreover, we have DOC 28, or DWD 218.17, which I'm just looking for that here, and I know that Michelle actually sent an email about this when all this was going down. And when we were having the problems with the portal, and let's see, I'm just looking for 218. So it's DW 218.17. Just a sec here. Okay, yes, on September 23rd, Michelle Sicard wrote to the tribunal, she copied in opposing counsel. Let's see, DWD 218.17 states in part that service is complete on mailing rather than on receipt. So those exhibits were not only sent electronically, they were also mailed that day. That's the law. I mean, if service is complete on mailing, then service is complete on mailing. But in any event, if the DWD has a portal and if they have a Dropbox and it's not working, well, that shouldn't be a litigant's problem. If a litigant tries to comply with the requirements and there's a technical difficulty, I don't think that the 14th Amendment's due process clause is going to allow for the government to say, oh, well, if our, too bad, so sad, you should have anticipated that nothing ever works right. We attempted to file those on time, and as soon as we learned that this wasn't working, we started emailing them.
Okay. Just for the record and for clarification, and all these emails are uploaded into the file. On September the 20th at 4:22, this tribunal and the parties were all copied, advised this tribunal that they were having difficulty with both the portal and the complainant's counsel's Dropbox, so unfortunately they were going to begin sending them. That witness list and exhibit list were obviously timely as far as being filed with me. Now the pre-hearing order does state in number 13, the very final paragraph of that section, that exhibits not timely received will be excluded absent good cause shown. As Attorney Hitchcock Cross noted yesterday morning, one of his things that he had brought up was the difficulty that he has experienced in trying to find things in the portal, load things in the portal. He's filed numerous things as well. So there seems to be some portal difficulty with uploading that. But in terms of what is required to be filed with me, that is defined as exactly that. Filing means when I receive physical receipt of that. Unfortunately, you also are required under 218.17 to not only file it with me, but you have to exchange that with the parties, that being said. Now, subsequent to that email, immediately after that, I want to say at 4:26, Attorney Hitchcock Cross, on behalf of her client, did ask and state that given my strict orders, they objected to the state's violation of same and asked that any submissions be stricken without review. Obviously, my orders state with good cause shown. So the next set of exhibits were filed at 4:28. The next set of exhibits were filed at 4:28. The next set of exhibits were filed at 4:29. The next set of exhibits were filed at 4:29. The next set of exhibits were filed exactly at 4:30. The next set of exhibits were filed exactly at 4:30. The next set of exhibits, which would have been, it says what, 75 through 87 is at 4:31. The next set of exhibits is at 4:31. That's 64 through 74. The next set of exhibits is at 4:31, 55, 63. The next set of exhibits is at 4:32. Again at 4:32. It seems, yeah, that's at 4:32. The next set is at 4:33, and again at 4:33. And 4:34 is the last set of exhibits. So we're not talking hours and things of that nature in terms of the delay in that, as those were mailed on the same day. I believe good cause has been shown for the delay. I was advised, as were the parties, as to what the difficulty was.
Your Honor, I just need to correct something. I was under the misapprehension that it was their Dropbox. It turns out it was our Dropbox. However, I had already begun, even before hearing this, emailing them to Attorney
She's
Cross.
already got one rule for the employer and another rule for the employee. I don't know that you entirely understood that.
Okay. My order says, my order is very clear. Filing with me, it's number 12, and it's by statute. I don't make these things up, okay? It defines what filing means. Filing means the physical receipt of a document. That is 218.02 sub 6. In my order, I state, pursuant to 218.17, that the names of the witnesses, copies of exhibits the parties intend to introduce at hearing, shall be exchanged between the parties and filed with the Equal Rights Division at least 10 days prior to the hearing, no later than September 20th by 4:30 p.m. And then the last sentence says, exhibits not timely received will be excluded absent good cause showing. They have made a motion to exclude anything that was beyond that 4:30 time. Okay?
Can I say something here?
No, not yet.
Okay.
I'm not done, because I've heard them
No, I understand.
say
It wasn't
stuff.
clear to me. I'm trying to.
No, I'm not done. Okay? Hold on.
Oh,
Again.
I'm so sorry. Yep.
Yeah, I'm looking for this other email that was sent. I believe it was from Attorney Zicard, explaining this delay. And that's the one I'm looking for. So hold on one moment. I seem to have been disconnected from because I want to see that yet again. Attorney Zakar, do you recall when that was?
When it was sent,
Yes, please.
let's say it was Monday, the 23rd. I'm sorry, I'm looking at my receipt, not my sent. It would have been sent by. So I think it was sent the afternoon of the 20th. No, yes,
The 24th, you say?
yeah. Sorry.
All right. Is anybody else frozen?
I am not.
No.
All right. Let me see if I can close out of that.
What are we doing now?
They've referred to some statutes. I actually want to see that
Oh,
email.
DWD, the.
Well, let me know when I can speak.
I will. I have not forgotten you.
Have you forgot Angela Ford, for example?
Attorney Hitchcock Cross, again, commentary regarding other cases and other, that's all gratuitous commentary. I've asked you to refrain from that. I've already had to do that once today. I'm not going to keep repeating myself. We are here on the Stolar's case. That's what we're here for.
I'm going to beg to differ, but you let me know when I can do that.
Now our computers.
I think we're having problems with the
Yeah, 'cause
network.
now mine, okay, there it goes, now it's working. Maybe.
All right,
Yeah.
just tell me what,
maybe
just tell me what statute.
reason Why we just have the record that's in front of us and not just able to refer to emails and to go like that.
Well,
That's
the
what we're
record
now
is what's
hearing
filed.
today.
Apparently, you're asking for a motion to exclude these things. I'm giving them an opportunity to respond to your motion. They've referenced things. So, since nobody's handed me the piece of paper and they're referring to something, I actually want to read it for myself.
Oh, I could forward it again.
No, I don't
I'm
want
sorry.
things.
I'm so
things,
sorry.
No,
Okay, yeah.
that's okay. Which
It was.
which statute are you referring to?
It's the administrative code, DWD 218.17.
Point 17. I believe I've already just referred to that.
Mhm. It's discretionary, no doubt.
Okay. For the purposes of this section, when you're exchanging names of witnesses and copies of exhibits, service is complete on mailing rather than the receipt. And it's discretionary as to whether I can exclude witnesses and exhibits not identified in a timely fashion. So when it comes to filing things with me, it's upon my receipt. When it comes to exchanging between the parties, it's upon the actual mailing of those documents. I've heard that we just simply want to exclude these things, which they council has every right to make that objection. I'm not. I haven't heard how excluding this this exhibit, which is proposed as 1380, is in any way prejudicial or impedes the justice of this. I have an explanation as to why these things were delayed, whether it was a Dropbox, a portal, or whatever. Those things are beyond somebody's, they gave notices as soon as they could as to what was going on. This isn't the first time a portal or filing or uploading has not worked. There are numerous emails from both parties having had difficulty with IT. I am not IT. I don't make the box. I don't even know how the doggone thing works. That being said, I am making a finding that any delay was less than 4 minutes, and I'm not saying where anybody has shown good cause, that anybody has been prejudiced by this 4-minute delay, and I am not going to exclude the exhibit. Okay, so that's my ruling on that.
Great. And
Attorney Hitchcock Cross, you wish to say something?
you got that right. Thank you so much. So here, it could not be a more clear example of how this tribunal is biased in favor of the state of Wisconsin here. And this is one of the most outrageous acts that I've ever seen, was this tribunal in giving the death penalty, throwing out the case of Angela Ford. Why? Why did the tribunal do that? The tribunal did that because Angela Ford supposedly, and this tribunal accepted the word of a government employer without any need to talk to the employee. And why did she do that? No.
Understand, I am in charge of these proceedings, not you, sir. I have already told you, I do not want to hear about other cases, other people. It has no bearing on this issue that is before this tribunal. We are here for Ms. Stolar's case. We are not going to interject other parties, other non-related cases. Your objection was as to these exhibits, and that is how we're going to do. Ms. Stolar is here for you to present her case. I've got a witness here providing testimony in this case. You are more than welcome to your opinion, sir, but we are not going to discuss other people's cases during this case. They are not relevant to the sole issue that is before me, and that is whether or not we can show by a preponderance of the evidence that the Wisconsin Fair Employment Law has been violated. So that's where we're at. And I will not hear further discussion on that. If you have something to say directly related to the exhibits, the 4 emails that I believe were rendered after 4:30, I will hear that. But otherwise, I've made my ruling, and please continue with your...
I have a lot to say, which is why I asked to be allowed to speak before you then cut me off, because you're not willing to hear examples of you making biased and unfair decisions against employees. That is what the issue is here, is that you have one rule for the employer and another rule for the employee. This is a biased hearing.
Your point is made.
Excuse me, I need to
No,
make for
we
the...
are not.
For
We are
the
not. I'll tell you
record-
what we're going to do. We're going to take a break. We're going to take a break, okay?
I'm
going to
make this
give
record.
you 10 minutes for you to figure things out, but I'm telling you right now, I will not have a disruptive hearing. I will not have a disrespectful hearing by anyone in this room. It is unprofessional. It is uncalled for. There is a thing called decorum, and I insist on it in a hearing. I have repeatedly, and I will not continue to say it, we are here solely for this. I don't want to hear what happened last week, last year, 10 months ago. I want to discuss the issues of this case. We are not going to be diverted regardless of how many attempts there are. You were given almost 2 hours to say anything you wanted to say. You did that yesterday morning. We have moved on to the actual merits of this case. We are in the middle of testimony. You made a very legitimate objection. We heard that. I heard from the other side. I made my ruling. We're moving on. You may disagree with my ruling. You have every right to do so. But I'm not going to revisit it, nor am I going to discuss other
Nobody's asked you
cases.
for any discussion. I am trying
It's
to
not
make
happening.
a record of my
Do not
objection.
interrupt me, sir. Do not, please. I'm asking again. It is disrespectful. We are not going to make a record in this case, and you are free to also put that on appeal. It's in the recording. On other cases that have no bearing to the facts related to this case and the issue before this tribunal, I will not have a mockery made of these proceedings. We are not going down that road. That is it. It's not going to happen. Okay? So if we could get back to focusing on this witness and her testimony, that is exactly what we're going to do. I'm
afraid
not going to
gonna
have
make my
disruptions.
objection on the record, and that's going to have to happen. So when we come back in 10 minutes, I'm going to still have to make my objection.
You can make an objection, but if it has to do with other cases, I will not hear it. And you can write that up on appeal as well. I do not want to hear about other cases that are not pertinent to this. I have said that before. I have issued orders of decorum between the parties and how they are going to be respectful to anyone. And for whatever reason, it should not have come to that. But it has. I expect my orders to be followed. I expect civility. It's not something that is outrageous and should not be expected. Okay? So, we're going to take a break, but I will not hear about other cases and other individuals because I'm here for your client to present her case, not hear about any of the other clients you may have represented in the past. That is not what I'm here for. Okay? So I'm now stopping this recording. We are back on the record. The appearances are the same. Once again, this is the case of Joanna Stolar versus State of Wisconsin Department of Corrections, and I believe that's the first time I've said that correctly. CR 2020 02513, Attorney Cross. I believe you are still in process, sir.
Great. If there's an eyewitness to a sexual assault by a sergeant against a correctional officer during the DCI fishing trip in front of other DOC coworkers, and this is reported to management, and there are no criminal charges, is it your testimony that the DOC would not do anything?
No, that's not my testimony.
Okay. What would the DOC have done if there were no criminal charges?
Would have written up a 15807 and investigated the matter.
And how do you know that?
Our policy says if we become aware of alleged work rule violations, we investigate.
Okay. And it's my understanding that the investigation did not start until after the charges were filed. Is that true?
Sorry.
Sorry, that's not in evidence.
That's why I'm asking her.
Can just lay an investigation. Does she know when it started?
Well, do you know when the investigation started?
I don't without looking at the materials.
Okay, well then let's do that.
I think she doesn't know.
I don't know where to look or what exhibit it is.
We're just
I
looking for the packet.
think he's going to direct you to that.
Do you? Oh, I'm sorry. Do we? I assume it's it's the one with the largest space in between it. But we can find it. Thanks for your assistance, everybody. I appreciate it. The comedy is appreciated as always. No, in their exhibits, the packet.
Okay,
we
hold
like
on.
staying here as long as possible.
Let's see if I can find it by a label.
This would be, it's somewhere therein.
It's under respondents exhibits. Let's look. Okay, here we go. Did you include it in an entire packet? Does anybody know?
Yeah, I think it's in the DOC's exhibits.
Okay, but I'm just wondering how it's titled. I've got assignments.
I don't know where it begins and ends in that pile.
This is a situation where normally the attorneys would be assisting each other. Right, no, I get that. You're fine, but, like I'm saying, just so that we don't waste court time, generally speaking, that's what people might do. Oh, okay.
I have nothing that says packet.
No, right, that's my
Yeah.
problem as well.
You stated a name. Is there like a form number that?
It's
Give me a second.
The form is 15807. Oh, it might be, I might have found it. It's investigation, Jason Touton. It starts on ERD 1244.
Haven't gotten there yet. I'm at 1200.
So it's in tab 11. At least that's part of it anyway. I don't know if it's the entire
Seems like
thing.
they found it.
It's 12.
Their version of
This
it.
is the beginning
Okay.
that you have.
Okay. 1244.
That's where it starts. This is all the other stuff.
Okay.
Are you good with that? That way if we need to find something, we know this is two times or something else.
So have you found the document?
I have found what maybe the packet.
Okay.
It's
Just-
on. Oh, I'm sorry.
Just to make sure we have this, the same thing, I'm going to, if I could, without objection from anyone, and everybody's welcome to come see. This is what I have starting on page 1244. Do the attorneys want to come see my laptop to see where I pulled it up? It might be easier. Is this what you're looking for? It starts at 1244,
That looks right.
and let me see what all goes through it. Oh, oops, I'm sorry.
No, it's fine.
It's 1244. Is that the packet?
That's our
Lem-
exhibit here.
Let me
Yeah.
go through the pages. It's 1244 through, and I'm going to go all the way down till I see another cover sheet. This is a lot of stuff.
Stephen is locked out of the building right now. He says he's locked out of the main entrance.
I can let him, or somebody can let him in
Thank you.
while I go through this. It even the 12 final conclusion is on 1268,
I think it's,
and then so the very last page is from 1244 to, what did you guys say it was?
It's 1243 to 1378.
I have 1244. I'm not going by your numbers.
1243 is the cover page.
yeah.
Okay, so 12. All right, 1244 through. What was the last one?
1378.
1378. Attorney Cross. Excuse me, Attorney Hitchcock Cross. Would you agree that that's the last page? Because I'm still steady scrolling.
I'm okay with that, sure.
Okay.
I mean, and just to be clear, I know you've got your documents that you have to maintain, but the real question that we're trying to find out is this going to assist her in answering your
Yes.
question? Okay,
Yes. it
great.
It will.
Yes.
Can I mark it?
Please.
Okay. All right. So this is going to be claimant number 4, exhibit number 4. It begins at 1244 through 1378, and I'm going to title this the Toutant Investigatory Packet. Anybody have an objection to that description?
We should do an intake interview.
Did you have an objection to that
No,
title?
no objection.
Okay, just to that title. Okay, it's been marked. It's been offered. Any objection to its admission?
No.
Okay, hearing no objection, it is admitted.
Thank you for letting me look at this. So
Of course.
So
Yes.
this was, the investigation was started by the institution HR director at the time on 2/6/2020. That's the date she filled out the first report. That is on page 12, or page 1246.
Thank you. That's really helpful. Thank you.
Okay, and you said that was started by the
The
HR
institution HR director, Gina.
at DCI?
Yes.
Okay, that's what I want to know.
And one last thing that I didn't catch was the date.
2/6/2020.
2/6/2020. Okay.
In the description on 1246, it says that Joanna Stolar had reported on 2/3/2020 about the incident.
Okay.
On page 1378, the charges against Toutant were first filed 2/26/2020, according to the CCAP.
Okay. Yeah, but those are the charges, right?
Yes, those are
Okay.
the charges.
Right,
I
but
thought
that
that
doesn't
was the
tell us
question.
when, that doesn't tell us when the department first learned that there was a police complaint, does it?
No, I would have to look further into this.
Okay. Okay. Now, when you're participating in the MAT group, are you acting as a rubber stamp?
What does that mean?
Well, you ought to just, is it pro forma, I guess is the word I would use, but are you actually making any decisions there?
We have active discussion, and then I would make my recommendation
Okay.
on the slip.
And you're actively thinking about what you're doing when you're at that time, right?
Yes,
Okay, weighing the positives and the negatives, right?
yes,
Okay, are other people at that meeting doing that?
yes.
Like Chrissy Preston, for example, is she weighing the positives and the negatives?
She would be participating in the conversation, yes. I can't speak to what is going through her head, but yes, she's listening to the same thing I am.
Okay, now how about Amy Pahacek? In your dealings with her, is she acting as a rubber stamp at any time?
I didn't deal with Amy Pahacek on this, I dealt with Secretary Carr.
I understand that, I understand.
So prior to dealing,
Anytime in your experience with Amy Pahacek, or if I'm mispronouncing that, please forgive me,
Pahacek.
did you ever notice her to be acting as a rubber stamp?
no.
Okay.
I would never characterize it as that.
I appreciate that. Now, Kevin Carr, you work directly with him, right?
Correct.
Would you characterize, based on your personal knowledge and experience, that he was acting as a rubber stamp at any time?
No.
Okay. And how do you know that?
I didn't perceive him to be U.S. if I felt like he, or I did not perceive him to ever be a rubber stamp.
I appreciate that. Okay. So, if Kevin Carr testified under oath that he was acting as a rubber stamp in the routing slip, do you think that would be true or false?
Kevin,
I don't want a witness testifying as to another witness's credibility and what their testimony might be. This is also speculative.
What's speculative? Excuse me.
Do you think is a question. You might ask her, do you have any reason to believe that your opinion or your perception might be wrong?
are you asking me?
Yes, we'll start with that. It's a great question. Thank you.
I don't think my perception's wrong. I don't think Kevin Carr is a rubber stamp.
Okay.
I don't necessarily know exactly what you even mean by that, but I do not perceive him that way.
Okay. Got it. When you talk to Kevin Carr about Toutant, do you give him information about the investigation anytime?
So I go through the summary, and then if he has questions, I answer questions.
Okay, so you're giving him some facts at that time.
Correct.
Okay. So, I guess is it true that Kevin Carr has no firsthand information of any facts which would give rise to any complaints or investigations with regard to Teuton?
I don't know what he has firsthand. I don't know what he has firsthand information on. I don't know what he saw. I know in my meeting, I talk through the summary and then answer any questions that there might be. I can only speak to what I do in my meeting.
Okay. And do you believe that you involved Kevin Carr in the decision making?
Yes.
Okay. And also in the investigation, was he involved in that?
I don't know what you mean by involved. I don't know if he was briefed along the way. I know that I met with him for a final decision.
Okay, on the investigation.
Correct.
Okay. And then he participated, I mean, he made the final decision, right?
Correct.
Okay. And you know that because you witnessed it?
I documented that I met with him on Teams and signed off on the slip that I met with him on Teams.
Okay. But also you have a recollection of meeting with him, right?
It was 4 years ago, so I don't recall the exact meeting, no.
Okay.
But I trust what I wrote down on that routing slip.
Did you talk to Kevin Carr about the Gerbinski interview?
I don't recall.
Okay, and you know what I'm talking about when I say the Gerbinski interview?
I think that's the person that might have come to the fishing event.
Okay.
I don't remember the name before, but I think that's what you're talking about.
Did you tell Kevin Carr that there was a witness to the sexual assault?
We would have talked about the summary, which goes into witnesses, what we could substantiate or not substantiate.
I appreciate that. What discussion, if any, did you have with Kevin Carr about whether or not a one-day suspension was appropriate?
I don't recall the exact discussion, but we would have talked about the
Well,
recommendation.
excuse me, don't tell me what you would have done.
Okay.
If you
I don't
only tell me
recall
if you
it.
remember.
I don't recall how our discussion went.
Okay. I appreciate that. Now, just in combination with Priya here, hopefully I'm getting to the end, but we'll see what happens. Did that Priya, and we got into some of this, but I don't think I was totally clear. Did that place any duties upon the department with regard to the Teuton allegation?
So when he was facing the sexual assault charges,
Mhm.
that's when we considered Priya when we were deciding whether to place him out on administrative leave.
Okay, and but then you decided because of Priya to place him out on administrative
We
leave.
did end up placing him out for a period of time. Yes.
Okay, and not because of the sexual assault that he was alleged to have committed on Joanna Stolar, right?
Well, the decision at hand was whether or not he should be placed out because of those charges. I have no idea what would have happened had he not been charged. He may have still been placed out. It depends.
I appreciate that. Sitting here today, are you able to tell us whether or not the DOC determined whether or not Teuton sexually assaulted Stolar?
We would have looked at what could be substantiated, and that is that we interviewed a lot of different witnesses. Definitely the fishing event had something that happened, and we could substantiate that there was a work rule violation.
How did you substantiate that work rule violation?
Through the investigation. So
Okay.
through the investigation, they identify if there's work rules, and there's a pre-disciplinary hearing, and we make a decision.
Okay. And what work rule was he supposedly violated?
I would have to look at.
Please.
This is the investigation. Actually, I'll look at the letter. The letter's on 1244, and engaging in outside activities which may impair the employee's independence of judgment or impair the employee's ability to perform his or her duties as an employee of the state. And I left out parentheses. So it's number 25, work rule, engaging in any outside activities, including violations or convictions of criminal or other laws, which impair the employee's independence of judgment or impair the employee's ability to perform his or her duties as a state.
How did Teuton violate that?
By the misconduct. He had a disorderly conduct, and I have the facts here on the letter. He had police contact, he was convicted of disorderly conduct, we investigated the behavior, and at an ice fishing event, he gave a coworker a back rub and described that his hands were on the side and then grazed her breast.
Can I interrupt, please, and ask what page you're reading?
1244.
Okay, because I'm pulling up a very similar letter on page ERD 1375. So you're referring to page 1244.
44.
And this was a letter from who to who?
This is his one-day suspension letter from Warden Jason Benzel to Jason Toutant.
1 day suspension letter.
But in fact, when it says Warden Jason Benzel on there, it's really coming from Kevin Carr, right?
The letter was signed by Jason Benzel, which he has the authority to sign once Kevin Carr makes the final decision.
Sure, but that's a good use of the word rubber stamp, isn't it?
I am not following.
Sure. Does the warden have any ability to say, yeah, let's put it another way. Let's say the warden says, screw you, Secretary Carr. I'm not signing your stupid letter. You're an idiot. What happens?
Somebody else would sign it.
Oh,
A
okay.
different appointing authority would sign it.
Oh,
The division administrator, secretary's office.
so that's what we call a rubber, and would that person be disciplined, do you think?
I don't know.
Well, as the head of HR, you don't know if
Hold on. There's an objection, and I think there's a supposition that somebody else wrote the letter and this other individual signed it. So I guess my first question would be, do you know who wrote the letter?
I don't.
If you don't know, that's
I
fine.
don't know.
But you know that normally what the person who writes these letters is employee relations, don't you?
They do help with the letters, correct?
And you're
But
the supervisor of employee relations, aren't
Yes,
you? And you knew that when you answered that question to the judge, didn't you?
I can't see who wrote this one. I don't know. I don't know those initials. to
But it's
know.
your understanding that normally the Department of Employee Relations, which you supervises, writes these letters and drafts them before the warden signs it. Isn't that true?
They review and edit, sometimes draft. It is not always ER that creates the letters.
Do you feel that there's a difference between review and edit and draft?
You asked me if they wrote it. I don't know who wrote this up. I know that they have a part in reviewing the process per the policy.
Okay.
I don't know who these initials are to know who wrote this.
Okay. But we're clear that the warden, if the warden doesn't, he has no choice, because if the warden doesn't write it, and it's a he in this situation, that we know that the warden, because the one time, the one female warden, something happened to her, so she's no longer there. So, right?
Objection.
Isn't that true?
Objection. Compound.
What happened to Warden Novak, if you know?
Objection.
What is the objection?
Yeah, it's not part of the case.
Okay, we're dealing with correspondence, and I've heard some testimony that part of employee relations might help with the letter, they might help with drafting, sometimes they do, sometimes they review them, sometimes they simply edit them. We don't know who wrote this. There's obviously multiple people that deal with these sorts of things. So I think his question is do you even know who this individual is? You either know or you don't know. I'm going to allow the question.
Do I know who Warden Novak is?
Yeah, I don't know who this person
yes,
is.
I know who Warden Novak
Okay,
is.
so she knows. Okay,
And what happened to Warden Novak?
if you know.
She retired.
Okay, and do you know why she retired?
She was under investigation and she retired.
Okay, and do you believe that she alleged sex discrimination at any time?
We had a case about sex discrimination.
Okay. And do you believe you still do, or something else?
I don't know if it's in appeal.
Okay.
Appealed.
Then,
Can we get back to the letter thing?
sure, did you have more that you needed to know on that?
Yes, I just want to make sure my notes are correct and I didn't transpose something correctly. So we're dealing with the letter that you referred to, which is on page 1244. It was issued on December the 8th of 2020. It says hand delivered, and then there's another date in writing. I don't know I can't even read other than the 2020. But it's 2 pages. It finishes on page 1245. And it's got some initials, JB by it and Jason Benzel. And is it your testimony that you do not know who wrote this letter? It's just in the packet.
Jason Benzel, yes, Jason Benzel signed the letter. I don't know who the initials are that actually typed up that letter that are underneath that. I can't off the top of my head figure out who typed that, which is what those initials likely mean. I also testified that employment.
Are you talking about the WJP?
Yeah, and CLS.
Okay.
And I also testified that employment relations is responsible for reviewing every single disciplinary letter that goes out. They don't always create them, but they definitely review, offer edits. There are times they may create it. I don't know who created this letter to begin with. That was my testimony.
Okay, that was all I needed for clarification. Thank you.
Great. Okay. I'm going to send to everybody a letter from Andrea Olmanson that I am going to use to impeach this witness. So it is not on our exhibit list. It will be a.
Objection.
Excuse me, please. It will be a rebuttal
Just-
exhibit.
Just let him finish his commentary. Once the parties have received the letter, then I believe you can then take a look at it. And then based on, I want to be the last person to see it if it's being offered. I want to hear argument first because everybody knows I don't like to be tainted by stuff. I don't look at stuff ahead of time. So have you done that, sir?
I've sent it to everybody, including you, but I sent it to you before you gave me that instruction.
I don't have my email up.
Great.
So
Problem solved.
problem solved.
All right.
So if Attorney Olmanson and Zakard could take a moment to look at this and then give me your response. And then, depending on the thingy, I'm gonna have to create a number.
I get it.
And I'm gonna give you, I'm gonna see what the last fate stamp number you have
Uh-huh.
in your exhibits, and then I'm gonna
I
start with
believe
that.
in you, Judge. You can do this.
I know I can do it. I'm
Okay.
just telling you what I'm gonna do.
Okay,
In case you wanna think of an objection, I'm giving you time to do one. But I'm gonna pick up with the
I
fate
can't
stamp.
see how I
things
can
like-
object to that, but I'll work on that
Okay.
in the meantime. and
All
in the
right,
same
please
time.
do.
All right. We all have our roles to play here, Judge.
I know.
All right.
Can I ask something? I don't know, what time did you send this at?
I just sent it seconds
just-
ago. This minutes ago.
Respondent's brief in opposition to complainant's motion to compel discovery and in support of its request for costs associated with being required to respond to complainant's motion to compel discovery.
And that letter has a reference on page 3 to another letter from Miss Olmanson that goes from the bottom of 3 and extends on to 4. And that's what I particularly would like to examine here.
Well, once we can figure out exactly what it is, because I will not put in the exhibit like 375 pages. I literally just want a
Oh.
page reference for the exact document we're talking about so I can give it a description.
Great.
So
And I just
somebody
wanna-
can figure that part out too for me.
Okay.
But your Bates numbers end up with 1058. So whatever this is, if we do something with it, it's going to be 1059. Just so we know.
So, this letter,
And as a matter of fact, I'm on, since I want to do an oodly and not hear discussions between counsel as to what your potential argument is going to be. I'm just going to pause the recording. Okay?
Okay.
And then we'll start right back up.